Okay, well, we got the law notes, okay, and we covered the foundation, and basically we talked about a court of record. The really important thing about a court of record from our point of view is the fact that the tribunal is independent of the magistrate. Now, the magistrate is a ministerial office. In other words, he can administer things. He cannot manage things. Management involves judgment and discretion. He can only administer. He can carry out the rules of the court, but he cannot make the rules of the court. Okay? The tribunal is the one who exercises discretion. Now, what is a magistrate? Well, let's get a little more detail. A magistrate, let's bring it up here, larger. Everybody can read it, I hope. A person clothed with power as a public civil officer. Okay? The tribunal is the one who does the judging. The tribunal has to be independent of that person clothed with power as a public civil officer. What does clothed with power mean? Remember the legal definition of power? It means the authority to make law, right? The source of the power. Well, reading this, you would think that he could make law. Well, he can't really. He's not a legislature. So there's restrictions on what he can do. But he is not the tribunal. See, to be a court of record, you've got to have the one doing the judging independent of the one who's conducting the proceedings, the magistrate. Now, it's a public officer belonging to the civil organization of the judicial, legislative, or executive. Oh, I'm sorry, I skipped a line. Public officer belonging to the civil organization of the state and invested with powers and functions which may be either judicial, legislative, or executive. But the term is commonly used in a narrower sense, designating in England a person entrusted with a commission of the peace. In other words, a cop, I guess. And in America, one of the class of inferior judicial officers, such as justices of the peace and police justices. Okay? The word magistrate does not necessarily imply an officer exercising any judicial functions, and might very well be held to embrace notaries and commissioners of deeds. See? It's a magistrate. So I'm a notary, so I'm a magistrate. Okay? So that's the general meaning of the word magistrate. But we can get more specific than that. For example, right here, California Penal Code, Section 807. Magistrate is defined. Is an officer having power to issue a warrant for the arrest of a person charged with a public offense. Who are the persons designated as magistrates? Well, the judges of the Supreme Court, the judges of the Courts of Appeal, the Superior Courts, the Municipal Courts, and the Justice Courts. They're all magistrates. Now, if they are all magistrates, and if the Constitution of California specifically designates that all courts are courts of record, and if a court of record is one in which the tribunal is independent of the magistrate, then what power does a judge have to make any decision? None. Right. Okay? So, if he doesn't have any power, who is the tribunal? Well, it has to be the sovereign. Well, the problem they have is that you can't, in a practical term, the state cannot prosecute anybody in a court of record. They've got to go borrow some sovereign somewhere, or, in the alternative, assemble a jury of sovereigns. Right? I question whether or not we have real sovereigns on the juries because they all receive a stipend. Stipend. So much per day. They get money each day for their I think they call it reimbursement of expenses, but there's no itemization of the expenses. It's just a general amount that's paid to everybody. Okay? So I have a lot of doubt as to the validity of that. And you see, there's some very intelligent people, apparently, who thought this all out. And you'll notice that they have arraignment in the criminal courts. Why do they have arraignment? Because they want you to agree to step out of a court of record and allow them to sit in judgment of your case. They want the magistrate to also be the tribunal, but they can't do it without your agreement. And this whole code system that they have set up is just that, a code system. It's not law. It's a contract. And you contract to it when you go through arraignment. Do you accept? They say you are charged with violating code section so-and-so. Are you guilty, not guilty, or nolo contender? Well, all three of those choices, nothing is there that says I object to the code. You agree to the code, but you're guilty. You agree to the code, but you're not guilty. Or you agree to the code, no contest. Okay? So, I guess I'm giving this here some sort of a paper. Ferretta waiver form. Yeah, right. Ferretta waiver form is the... By the way, the Ferretta waiver form, where they're saying, do you understand certain things or not, and so forth. And it's actually, let me have this back. I want to read the last sentence here, because now you'll all see the significance of this. It says right here, number 7, on what their
how do you spell Ferretta?
It's F-A-R-E-T-T-A. Anyway, it says your right to represent yourself may be ended, an attorney appointed for you, and you may be excluded from the courtroom if you misbehave during this case or seriously disrupt the trial. That's true, and so forth. Anyway, if you elect to represent yourself, you will not be successful in any appeal based upon the quality of your representation, and so on. Well, all right, but notice they talk about representing yourself. What's really going on is that they're giving you schizophrenia. Yeah. They're splitting you. Right. It's kind of like, you've heard of the straw man concept. Yeah. Okay, well, I don't understand that, but this is similar to it. And that is that in this capacity, you're an attorney. The court is granting you the privilege to be an attorney, even though you're not, quote, licensed. All right? And on the other hand, you're you being represented by your other you, the attorney. Now, the minute you accept an attorney to represent the real you, you have admitted the jurisdiction of the court. Okay? Now, here's what the very last page says. The very last statement they say, or question. Do you now wish the court to permit you to represent yourself as your own attorney? Permit you. If you accept the permit, you're in their jurisdiction again, right? To represent yourself as your own attorney. No, when I go to court, I am myself. I am in my own capacity. There, now pass it back. Thanks. Okay? Right. So anyway, back to this. The persons designated as magistrates, these are who they are. All the judges in California are magistrates. And yet the Constitution requires a court of record, so they have to have some way to get around it. They do it with the arraignment process. Now, in a civil case, it's different. You go in as a civil case, they assign a judge, you walk in, there's no specific agreement to let the judge do the judging. But by your actions, you enter into the contract. And all the TV shows, all the propaganda is to educate you into accepting the judge as the authority. When in fact, if you're the plaintiff, you own the outfit. It's your court. You see the difference? So you should always object to the penal jurisdiction. You want that court of record. And where are they going to find the sovereign of the court? Well, they'll have to get it through a jury. But you don't ask for a jury. You just demand the court of record. You don't say you want a jury. Okay? You'll take a court of record without a jury, right? All they have to do is find the sovereign of the court. I don't think they can do it. Who's the people of California? Right. And if somebody does step forward and say, I'm the people of California, really? You're the whole outfit? Dictatorship? Does anybody know the meaning of the word dictatorship? Okay. So that's more stuff. Okay. Let's see, what is this? All right. What's a lawsuit? Well, here's Old English law. A lawsuit, a suit, is the witnesses or followers of the plaintiff. That's what a suit is. You see, if you go back into biblical law, which I think is what? Leviticus is where it normally is. Okay? The old biblical law, the victim and the witnesses were responsible for the prosecution of the bad guy. Okay? So, here it is in Old English law too. The witnesses are followers of the plaintiff. That's third volume of Blackstone's Commentaries, page 295. So, but when you have a court is the person and suit of the sovereign. What it is that the king is sitting on his throne. You're the king, you're on your throne, and you have the court. The court is all these courtiers that are in your court. Or, in other words, your witnesses. That's what the suit is. So, in modern law, they say a generic term of comprehensive signification and applies to any proceeding by one person or persons against another or others in a court of justice in which the plaintiff pursues in such court the remedy which the law affords him for the redress of an inquiry or the enforcement of a right, whether at law or in equity. Pretty well covers it, I guess. So that's what a suit is. So when you put this all together, I'm the sovereign plaintiff. I have my suit. That creates the court. I call it a court of record. It's a very specific kind of court, a court of record, as opposed to any other kind of court it could be. And in a court of record, I've hired a magistrate, state magistrate, right, judge, but I make the decisions because I'm the tribunal. I'm the king. I sit on the throne. All make sense? Okay, what's a tribunal? The seat of a judge, the place where he administers justice, the whole body of judges who compose a jurisdiction, a judicial court, a jurisdiction which the judges exercise. Well, yes, a judge, a real judge, does judging. But if you're a magistrate, you can't judge, because if you do, that makes you the tribunal. Okay? All judges in the California courts are magistrates. If you let them be tribunals, well, you can, but you can stop them too. Okay. What's a court? The residence of a sovereign or similar dignitary, a sovereign and his officials and advisors as a governing power, an assembly of the retinue of a sovereign, an open space enclosed by a building or buildings, a space walled or marked off for playing a game, such as tennis or basketball. The place where justice is administered, also a judicial body or a meeting of a judicial body. Okay? Now, I want to bring out something else, as long as we're approaching it here. Minute orders. Ever heard of a minute order? Oh, boy. Let me tell you something. You're going to love this. A minute order issued by a judge is not part of the record. A minute order issued by a judge is not an order. Did you know that? What it is this. This is all part of the scam again. In a court of record, you know that in a court of record, the judge or the magistrate cannot make any decisions. Only the tribunal can make decisions. Okay. So this is mandated by the California Constitution, the 1879 version, the second one. Since they all agree that's it, I'll use it, all right? Even though it's not the real Constitution. So if it mandates a court of record, then how are they going to run this thing? Well, what they do is they issue minute orders. As long as they can bamboozle you into thinking that that is an order, then they got away with it. Okay? Why is it called a minute order? Well, it's actually, that's what everybody says, a minute order. But let's say it correctly. It's a minute order. Minute, the word minute means small.
Very small.
Very small, right. In this case, it means small rather than very small. Okay? The reason, what it is this. Back in the old days, when they made up court papers, you'd file your court papers. By the way, the word file means wire. Because when you filed your papers, you gave them to the clerk put them in a pouch, and the pouch was hung on a wire. It was hung on the file. Eventually, the word came to be used to mean you're given the papers. They are filed, right? They're put on the wire. So that's what file means. Well, in that same era, when they were filing papers on wires, whenever a court order was issued, it was written in a large hand so that everybody could read it. Remember, not everybody could read in those days. Literacy was pretty low. So they did it in a large hand. Those were all court orders were written in large hand. The clerk's notes were written in a minute hand, a small hand. Okay? So anything that's minute in court terms are clerk's notes. And remember, the judge can act as a clerk. So he issues a minute order. Now he has not violated the definition of a court of record. Okay? In fact, no order has been issued at all, so he can't be in violation of a court of records definition. So, if you accept it as an order, well then great. There you are. Yes?
So when you file in papers and they stamp it received, they're not hanging it on the wire.
Well, that in the old days, that's true, but guess what? It still goes in the file, and under common law, we don't care if it's received or filed. It's there for the world to read. It's there by sovereign authority, right? You filed it. Right? Yeah, and if you have trouble filing a paper, all you have to do is say to the clerk, file it on demand. Okay? The problem is this. The clerk, pretty much the job of the clerk is dependent upon the satisfaction of the judge. So if the judge is not happy with the clerk, how many promotions or raises do you think the clerk will get? Okay? So the judge is a very strong political force and a strong factor in the career of a clerk. Well, the clerk has a problem here because it's your court, and if you file something, it should be filed. So how's the clerk going to deal with this serving two masters? Well, what they do is they have this little stamp called, and it says, when they stamp it, it says, filed on demand. Okay? And when you tell the clerk to file on demand, she reaches under the counter, gets her little special stamp, stamps it filed on demand, and then when it goes to the judge looks at it, he knows that the clerk tried to carry out his scam, and it didn't work. See? So that's how you force a paper to be filed. Now, as an alternative technique, if it turns out that you have a lot of trouble, they're even refusing to file them on demand. I don't know if it'll still work, but in the past, when we had real difficulties with the clerks on that, we would send them in by registered mail, and they always got filed. I have no explanation for that phenomenon. I just know that that has happened in the past. We were 100% successful by registered mail. Not mailing them in, but registered mail in. Okay? I'll leave it to somebody to do research on that.
We were talking earlier about a criminal complaint and that they would refuse to file a cross-complaint.
Counterclaim.
Counterclaim. Could we do it on demand, or?
Well, we haven't tried that. Like I said, the last time I did it, I just rolled with it. It didn't matter because, see, it's the whole LA court system. You understand that every county has only one court. You don't have a county with two courts. You might have a county with several divisions within the court. You might have a county with several court buildings, but there is only one court in any county. So if you have a criminal proceeding here, at least theoretically, you should be able to have a counterclaim over in the civil division. It should be a counterclaim. But I ran into so much ignorance that I just went ahead and scratched out stuff. And because it's all heading stuff anyway, headings don't affect substance. Okay? Y'all understand why I was able to do that, right? I see, don't understand it. Well, whose court is it? Mine. You know, there's a rule in the courts, in the rules of court, that says that things have to be a certain way, you know, whatever. And then there's a little freedom clause that says something to the effect, unless the court orders otherwise. Okay? So if your papers don't really match up, you could have it filed by sovereign command, sovereign order. Of course, that's what you're doing when you say file on demand anyway. But, you know, I tend to sometimes get practical rather than fight out every little issue. And so, you know, if it didn't, again, titles and headings do not affect the substance of your suit. So as long as the clerk said nothing about the substance, I said, well, what do you want? What are your requirements? Now, you know that no clerk can give advice, right? You've heard that over and over again. All right. When you go up to a clerk, don't ask for advice. You're not going to get it. But what you can do, when you run into a problem, all you have to do is say to the clerk, well, what do you require? Now she's not advising you. She's telling you what she requires. Yes, sir.
A suggestion on this, instead of scratching things out and doing it that way, make everything the way you want it and make a cover sheet with titling the way they want it and put on the right side cover sheet.
That's a good idea. Never thought of that. Excellent idea. Sure. Make up the cover sheet the way they want, and right behind it you have the way you want it. Yeah. That shows your real intent. Yes.
I did that in federal district court,
Uh-huh.
and they read through it. They were reading through it before they took it back to the judge's court.
Sure. And what happened?
They kicked it back.
Okay. Well, you can't win them all unless you want to fight it out. But you know, like I said, the titles and headings do not control. What controls is the substance that's written in your paragraphs. So in the paragraph, I identified the parties as counter defendants, or you know, we're the counter plaintiffs and they're counter defendants, and we cited the case. By the way, when you do a counter claim on a criminal proceeding, you need to take all of the paperwork that's available to you, the criminal complaint, whatever you got, and enclose a copy with your complaint if and only if you have new defendants. Okay? If you do a counterclaim against the state, it's like the state versus you, and you're going to do a you versus the state, then you don't have to do that. But if it becomes you versus the district attorney, or you versus the public defender that's forced on you, then you need to have a copy of the complaint because he is a new defendant. Okay, so you make sure you put a copy of the original criminal complaint. They have the defendants, the counter defendants, should have some understanding of what the fight's all about. So they're entitled to a copy of the paperwork. Okay, well. Okay, now here's another interesting thing. You'll like this one. The proceedings of the courts of common law are records, but every minute made by a clerk of a court for his own future guidance in making up his record is not a record. There you are. See, a minute order, not a record. What is a record of a court? All a record is a list of what was the issue and what was the decision made. That's it. That's the record, the real record. Now, I know we get kind of sloppy with our language, even in legal language. And so we tend to say everything's a record. You know, we get a copy of the docket sheet and that's the record. Well, technically speaking, the record is only those points where what was the issue to be decided? Like a motion to dismiss was made. Was it granted or denied? That is the record, regardless of the other print around it. Yes.
That's the docket then.
Well, it's part of the docket.
Okay, because usually...
It's buried in the docket.
Because in the docket, we find a list of what you just described.
Yes.
Plus, we'll find a description of the minute order issued by the judge in that docket.
Yeah, but that's not an order, is it?
I know, but they label a
Yeah,
minute
so
order.
the
But if
clerk
it's listed in the docket, then would it be official?
Well, the clerk, no. The record is the actual, look, it said, well, read it right here. The proceedings of the courts of common law are records, but every minute made by a clerk of court for his own future guidance in making up his record is not a record. So I made some extra notes. It's mixed in with the real record. You know, they don't distinguish it. They don't put one in black ink and the other in red ink. You know, it's all mixed together. But you should understand that the real record is the issue that was, the motion that was presented, for example, the issue that came up, and what decision was made. Everything else is notes.
Well, actually, isn't the record what the court reporter writes?
No, I just told you. It's the decision that was made on the issue that was raised. The court reporter is just, that's a side thing. I mean, sure, they make mention of it. They say who the court reporter is, and sometimes you put in a copy. It's nice that you have all that history. But a record specifically means what was the issue and what was decided. Not how it was decided, but what was decided. Okay? Read the next paragraph here. Proceedings in courts of chancery, that's equity, by the way, are said not to be, strictly speaking, records, but they are so considered. Now, there you are. They're not records if you really, really want to get strict on the meaning of what record is. But it's obvious the notes are important and everybody's interested. So they call them records even though it's not accurate.
What's equity? What is that?
Well, the story goes that the king laid out all these laws, and those laws he created were called common law. And then the judges could only make decisions based on the law. And if it wasn't in the law that the king made, you couldn't recover. So that wasn't too satisfactory. So what they did, the only thing you could do is if you didn't like the results of the law, you had to go directly to the king. Well, the king got busy, so he created a new class of judge, only he didn't call them judges. What he called them was chancellors. So the chancellors were in the equity courts. Equity, like fair play, okay? And so the chancellor was the king's right-hand man. The chancellor could make law on the spot, as opposed to the judges who could only judge a case based on pre-existing law. So the chancellor would make up a law to cure some sort of problem, whatever it may be. So the court of chancery is an equity court. And the judge that's sitting in the equity court is not properly called a judge. He's actually called a chancellor. Yes.
So in other words, after 1938, when
Start over. You were away from the mic.
After
when you started
1938, when they blended law and equity together to have this new type
They
of...
didn't blend it together. What happened was that they took these words and they put them in the same book. They
Okay.
mixed them, but they weren't blended. So
Okay.
that because of the fact that the Constitution of the United States says the judicial power is available in all cases in law and equity, and because the Seventh Amendment says that no decision by a jury sitting in a case at law can be reviewed in any court, because the Constitution makes the distinction, they cannot pass any legislation to erase that border. So what they did, because after all, frankly, common law makes it tough for judges to screw you. So what they did is they went as far as constitutionally could go, and that is they listed them all in a book, and they don't tell you which one's common law and which one's equity. And if you look at specifically the rules of court, and I think it's rules 7A and B and C, and I'm not fresh on this, but I think rules B and C contradict each other because one of them's common law and the other's equity. But if you read it closely, they seem to contradict each other.
So how would you define the Nisi Prius court?
Well, that's a whole separate issue. That has nothing to do with your first question, right?
Okay.
You're raising a new question.
Well, after 1938, they blended.
No, 1938 has nothing to do with that. The Constitution is the same today as it was then.
Well,
okay?
I know that, but
Huh?
I know that, but then we have corporation courts.
Well, that may be, but that's another issue.
Okay.
Okay? If you don't want a corporation court, insist on a court at law.
Okay.
You know, insist on a court of record. And if they don't give you a court of record, the obvious next step is to do a counterclaim because they went beyond their jurisdiction. Right. Only a court of record is authorized. Okay? That's the only way they can get jurisdiction on you is with a court of record. And with a court of record, the requirements are very tough with a court of record. They have to have an injured party. If nobody's injured, where's the case? That's what it is. You're entitled to a jury of peers, meaning sovereigns. There's all kinds of stuff in courts of record that make it tough for them.
So it flips the court.
Yeah. You see, you're innocent until proven guilty when you're in a court of record. When you're in an administrative court, corporate court, whatever you want to call it, you're guilty until proven innocent. Yes, sir. You need the exercise. There you go.
Do you ever ask if the court is in chambers or in session?
It's always in session. Doesn't matter if you're in chambers. The court is always in session. You look at it. It's somewhere. Even in the statutes, they say the courts are always open, and it's true. There is a judge on duty 24 hours a day, 7 days a week in every county in California. Okay? There's always somebody who's got the duty assignment. Yes.
When I was arrested one time, and I wouldn't give them jurisdiction, they finally said, "Okay, come with us." And halfway down the hall, they said, "Unless you submit to the jurisdiction," I said those exact words. The Supreme Court has said that the court is open 24 hours a day, 7 days a week, 365 days a year.
That's right.
And they said to me, "Back to the slammer."
Well, I mean, they break the law. I mean, I keep going back to that example. You know, you're going down the street, robbery's outlawed, but you can still be robbed, you know. So, yeah, you want to tell me cops break the law, I understand that. That happens. Okay. So, so strictly speaking, the courts of chancery, the equity courts, are not courts of record, and therefore the records that they keep are not true legal records. So a minute order is their way of getting around that requirement. But it's not a perfect way. The weakness in it is that they've got to somehow take advantage of your ignorance. Because if you find out, that blows the game. Now, if you find out, you let them know that you found out, they may not believe you. In fact, they'll choose not to believe you, even if they do believe you. So, you know, it's not, on a practical level, it's difficult. But if you're talking strictly legal theory, if you know what you're dealing with, if you know that a minute order is not an order, that's easy to counteract. In fact, in what we did just recently in a case, and of course we haven't followed through yet because they're choosing to break the law as far as I'm concerned, but they issued a minute order putting a person in Patton State Hospital. And we issued an order signed by the patient ordering them to let her go because it was a minute order and not a real order. They haven't responded to that, but you see, they could get in trouble over this one Because here's the thing. These guys down here on the lower level, well, there was a guy named Goethe who was a philosopher in Germany. And he said that there's nothing so fearful as ignorance in action. So we're dealing with a lot of ignorance. And these people, you know, you bring them the law, you can give them all the explanations, but their arrogance takes precedence. Their arrogance, you know, you give a gun to a baby, he could hurt somebody. And here, these people are this way. So, but you're building this record. At some point, somebody's going to lose his job. Something's going to crack on this, because there are people higher up who do understand these things and will not trash the system just to win this one case. That's my theory. Now, I have to tell you, if everybody up and down the line is against you, you're not going to win. Okay? But hopefully there's somebody honest in there, and my experience has been that we do run into honest people. Okay, so, all right, here's an author, Tollier. He says that minutes are called because the writing in which they were originally was small, that the word is derived from the Latin minuta scriptura, in opposition to copies which were delivered to the parties and which were always written in a larger hand. So minutes, okay, so the copies which were delivered to the parties were in large hand. The copies that were not delivered to the parties, the court clerk's minutes, well, that was a small hand. And what's a minute book? It's a book kept by the clerk or prothonotary of a court in which minutes of its proceedings are entered. So a minute order, I presume, is going into the minute book. Okay? All right, let's see. Court of record, let's see. All right, let's go to an actual example where all this stuff was applied. Okay? This is a case that was in San Bernardino County. The names have been changed to protect the guilty. But basically, let's take a break, okay? I'm kind of feeling it myself here. I think we can fix that. As soon as I get... You caught me dressing. Okay, well, let's get into an actual example here. Okay, so here's the example. Basically, what I want to do is kind of run through this case, and what we have here is the we have the sovereign suing somebody because somebody went through a stop sign, or actually stopped at the stop sign, but then went into the intersection, and the sovereign plaintiff was riding his bicycle, and that when he got struck, it resulted in several injuries. Guess he's having a good time out there. He had several injuries which amounted somewhere around $50,000 to $75,000 in surgery. So the California Vehicle Code says that whenever a licensed minor gets involved in an accident, the liability is limited to $15,000. It also says that the liability of the parent is limited to $15,000. And it also says that the aggregate total of the driver's, the minor's liability and the parent's liability is $15,000. And they had $15,000 in insurance. So that meant that the victim paid the majority part of the loss. Okay? Well, nobody wanted to yield, so they got sued. And basically, what the plaintiff said was that, A, they're responsible anyway for the whole thing because he sued under common law. And the common law says that there's always a remedy. Okay, there has to be a remedy for every wrong, even if you have to make up a remedy. So he sued under common law, and he also sued the state of California because the state of California, you see, the state, normally a lawmaking body does not have liability for the laws it makes. And the reason is because it's just setting up some suggestions. Okay, remember, this is a republic, and the laws are not mandatory. They're advisory. So these are the suggestions that they have. So normally they're not liable. However, when a state jumps into the fray and participates in the commerce, then they lose whatever sovereign immunity they claim even under statutes, and they become just as liable as any party. So what the plaintiff said in this case was, well, the state of California, first of all, licenses the driver. It doesn't just pass a law, it licenses. It examines the driver. It does quality control by having quality control agents out on the street called traffic cops. Okay? It participates in programs. It's an active member of this whole environment. And as a result, they have a liability. Well, of course, they denied that. They did a demurrer. And in their demurrer, a demurrer, by the way, anytime you make a demurrer, anytime anybody makes a demurrer, whoever makes a demurrer automatically agrees to all the facts. All demurrers are based on law. Well, not really all, but from your standpoint, they basically are. Yes? Oh. So, a demurrer, don't ever do a demurrer unless you're ready to agree to the facts. You see, whenever somebody sues, you make all kinds of claims about facts, you make all kinds of claims about law, and you say because of these you're owed money. Well, when you answer a lawsuit, normally you say, no, the facts are wrong, and no, the law is wrong, these are the real facts, and this is the real law. That's how it normally goes. But in a demurrer, basically a demurrer is half an answer, because the first half, where you challenge the facts, is not there. You agree to all the facts. Okay? And so the only thing left to argue in a demurrer is the law. Okay? So you argue the law. Now, an interesting thing about that is that if you argue the law, you can now, purely at the discretion of the court, if you put in a demurrer arguing only the law, once that demurrer is settled, the court, at its own discretion, can jump straight to the judgment, no trial. Okay? We have a court case going now, I've told you before, about the 4 judges. It's also against a half dozen DAs, 5 public defenders, and a few other misbehaving people. And every one of them demurred. Every one of them. Wait till that last demurrer gets answered. We're going to have fun with that one. Because they all agreed to the facts. We said that a motion was made for challenging jurisdiction. And not a motion, but we challenged jurisdiction. And they admit that. We said they never did anything to respond to it. Their demurrer says that's true. As a matter of fact, the demurrer that was offered by the judges, they specifically quoted the case that says that they agree to all the facts if they demur. Okay? Do you see the word stupid? Not at hand, but yeah. It's Aurora's case. Anyway, it's a case that's in process right now. Anyway, this is a case that, by the way, it's still going. We're getting ready to write the final judgment. In fact, I would have written it a month ago, excepting for the fact I got really entangled in another case. So, but anyway, here's what happened. The plaintiff filed an action for trespass. Now let me explain the difference between an action and a complaint. They're really about the same. But an action basically is the court proceeding. A complaint is a court proceeding with a magistrate. That's basically the difference. Okay? All right, so there was an action for trespass. It was a badly composed action. So later on, we filed a first amended action to fix the problems that we found in the action. So it's just there for the record. It really isn't, should not be used as an example. But then the opposition did a demurrer, okay? And in his demurrer, he says the usual things that they all say in demurrers, which is that there was a failure to state a claim upon which, here it is, the complaint fails to state facts sufficient to constitute a cause of action against defendant, okay? And also the complaint is uncertain, ambiguous, and unintelligible. Now this is just boilerplate stuff. And what that does, that sets it up so that the judge, if he is in fact acting as a tribunal, will use his discretion to say that he doesn't understand it either. It doesn't matter how clearly you wrote it, he won't understand it, okay? In fact, this was noticed by an English judge. Again, I can't quote him exactly, but what he said was that everybody is presumed to know the law except His Majesty's judges who have the Court of Appeals to set him straight. But anyhow, this is boilerplate, okay? So this is, to all parties, please take notice, okay? And that's his notice, so that's not the demurrer. Then he makes his points and authorities, okay, where he says there's a point, and then he cites his authorities. And again, in the prior seminar we had, we went into what points and authorities were, so I'm not going to go into it here. But basically the points and authorities, and he makes all his points, and he has his conclusion. Now what's interesting about this, and I didn't notice this before, otherwise I would have made some hay with it, but he never gave us a demurrer. He gave us the notice, please take notice. He did say that, here it is, let's see. The court will hear the demurrer, right? And then he makes some points here, but he didn't label it as the demurrer. This is he put it under the heading of notice. Now it's true, headings don't control, but on the other hand, you are supposed to have a notice, you are supposed to have a specific demurrer, and you're supposed to have a specific points and authorities. Well, he left out the actual demurrer, although the actual demurrer would probably look exactly like paragraphs 1 and 2. But there's an interesting point about this, paragraphs 1 and 2. You notice that this is a general demurrer. He just makes a blanket statement, right? I don't understand it, right? Well, if you look in Bouvier's Law Dictionary under demurrers, you'll find a case there that says that whenever they make an objection that's general in nature like that, where they don't get into specifics about just exactly what it is, what part they don't understand, then the court must deny the demurrer. No option. It must deny it. So they're leaning on the idea that, hey, we're a member of the club, we're the attorneys, the judge is on our side, it'll get denied. And it normally is, because judges don't like amateurs in their courtrooms. Okay, they like trained attorneys. So that's what. Well, anyway, what happened was in this demurrer, it did get denied, okay, rather than granted. For some reason, the judge did deny it. Well, we knew we had a defective lawsuit, and what we were aching for was an excuse to revise the lawsuit, okay? And this judge gave it to us when he denied the demurrer to the opposition. If he had granted the demurrer, then the demurrer would have been the issue, not the lawsuit. But since he denied it, we basically came back with our own thing. But let's go to the actual transcript. No, for some reason it's not going there. All right. I think my computer went to sleep on me in some aspect. Okay. Okay. So here's the transcript. So this is what went on in court. So he says, he calls the case, and then the plaintiff and defendant's attorney respond, and he says, they get into discussion. He had a tape recorder. The plaintiff had a tape recorder, and the California rules of court say that you can't have a tape recorder unless you get the permission first of the court. They don't like having live evidence, okay? So anyway, they got in some discussion, and the judge says, you are to turn off that recording device or leave the courtroom, one of the two. That's the order of the court. So the plaintiff says, well, excuse me, Your Honor, this is, and the judge says, that's a standing rule of court. So he says he has a problem hearing, and the judge says, well, we have a court reporter. I do not allow tape recordings in this court. That's a California rule of court, period. See? It's not a California rule of court, period. It's a California rule of court, but you can get permission. But the judge doesn't like that. Okay. Well, anyway. So the judge said, he says, there are ways to take care of that also. And the plaintiff says, well, how would that be? And the judge says, well, I'm going to explain some procedures to you. You may leave the recording on as I explain the proceedings to you. Then you're going to turn it off, okay? All right, very well, he says. Are you an attorney at law, sir? No. You filed a lawsuit in this court. I have to hold you to the same rules. Are you hearing me? Yes. Tell me if you don't hear me, okay? Yeah. If you would speak up a little bit, please. All right. I have to hold you to the same rules that I do everybody else. That practices law in my courtroom. My courtroom, right? Yeah. This is the people's court, not his court. But nevertheless, he says my courtroom. Those are the rules of the court. You notice how authoritative he speaks. Okay? He says, so he says, which rules? And judge says, in other words, I have to hold you to the same standard as anyone else who comes into my courtroom, including the attorneys who have knowledge of all the rules of court. Which rules of court are you talking about? California rules of court, period. It's called California rules of court. Okay. And he says, well, then, all due respect, sir, then I must object for the record. Okay. And the plaintiff says, this is a court of record, and we have chosen these rules that govern the procedures of this court. Judge says, that's right. I have California rules of court. I don't know what you're talking about now. He says, well, do you have my action? Yes. In front of you? Uh-huh. Well, the second paragraph. Judge says, I'm trying to explain to you, sir, that you will comply with the California rules of court, and you will be held to the same standards as any attorney who practices in this court, because those are the rules of court. And so one of the rules of court is we do not allow electronic devices. And so he goes, okay? So you've got the character of and what this judge is without us going through the whole thing. All right? So let's go. That was pretty much that. Now, we go down here to, okay. What he did is the plaintiff basically, when a judge misbehaves in there, when he issues an order. Now, you understand that you cannot attack the discretion of the judge. Once you give him discretion and he uses it, you cannot be unhappy that he used it. After all, you said you can use your judgment. Okay? So discretion on the part of a judge, unless it really goes overboard, and I don't know how far it has to go over because I've read some pretty horrible things. But the judge, if he has discretion, he can exercise it, and you have no complaints when he exercises it, no matter how he does, even if he does it maliciously, believe it or not. But if he has no jurisdiction, it doesn't matter how little the discretion is, it doesn't matter how right his decision is, it's not allowed. Okay? So, the way you do, when the judge makes a decision, he is now outside the court. Even if he's sitting on the bench, he's outside. When he takes that decision and gives it to the clerk, and the clerk files it, that is an error in procedure. Why? Because the clerk is accepting a ruling from an unauthorized source. It's not from a source that used bad discretion. It's from a source that never had the authority in the first place. Okay? So the discretion that is not allowed, and if he files an order, which he's not allowed to do in a court of record, because the tribunal is supposed to be independent of the magistrate, right? That magistrate files that order, the clerk made a mistake, and that is the error. It's not an error in judgment, it's an error in procedure. Okay? Now, we have a way of correcting that error in procedure. It's different from how you correct an error in judgment. An error in procedure is real simple. All the sovereign has to do is issue what's called a writ of error coram nobis. Okay? Writ of error means we're correcting the error in procedure. Coram nobis means the court is correcting its own error. That's different from a coram vobis, which is a higher court correcting the procedural errors of a lower court. Okay? Okay, so we do a writ of error. So you see here, we have a writ of error. But before we get to the writ of error, we had to do a few things. So the first thing we did was a judicial notice. Now, a judicial notice means that the court takes notice of something. Okay? There are certain things that a court can automatically take notice of. For example, it can take notice of the English language. It can take notice of the laws. It can take notice of the court records. These are all things that do not have to be proven in evidence. Okay? They stand on their own without proof. They are there. So, thank you. So that's a judicial notice. Now, when a court takes judicial notice of something, these are things that the court will consider when it arrives at some decision. Okay? It just considers it. That's different from a judicial cognizance. A judicial cognizance is one notch higher. In a judicial cognizance, whatever it takes cognizance of, that is mandatory on the judge, and it has to be compatible with the decision. Whereas if the court takes judicial notice of something, it's advisory. It's kind of like, okay, we'll see if that matches up with this. We notice it, we accept it as valid, but it may or may not apply to this case. In judicial cognizance, it must apply to the case. The case must be consistent with the judicial cognizance. In this case, we picked a judicial notice. So here's what the judicial notice said. The court, on its own motion, takes judicial notice of the following. All items mentioned in the California Evidence Code, sections 451 and 452, among which is included the Federal Rules of Civil Procedure. So any rules of civil procedure in the federal rules, we can take judicial notice of. Okay? Now, this is the sovereign who's issuing this judicial notice. When you are the plaintiff or you are the defendant, either way, you can apply to the court to take judicial notice of whatever it is you want the court to notice. But in this case, the sovereign himself, in his sovereign capacity instead of plaintiff capacity, the sovereign, as part of the court, issued this judicial notice. Okay? And so he's saying, we notice the Federal Rules of Civil Procedure. Now, the reason he did this was because in his original action, he did specify the federal rules of civil procedure would be the rules of the court, not the California rules of court. Okay? You can set up any set of rules you want. You can make up your own rules if you want. But what I generally do is I adopt the federal rules of civil procedure. Main reason is because they're simpler. Okay? And I know them better, and they're universal all throughout the United States. So, okay, the records of this court in general and the reporter's transcript of the proceedings on February 18th and so forth. So that's it is the public policy of the state that the public agencies exist to aid in the conduct of the people's business. The people of this state do not yield their sovereignty to the agencies which serve them. California Government Code, we take judicial notice of that. And we take judicial notice of the same thing in the 54-950. And we take judicial notice of the case that said that at the Revolution the sovereignty devolved on the people, and they are truly the sovereigns of the state and so forth. We took judicial notice of the meaning of sovereignty. We took the judicial notice of the rights which formerly belonged to the king by his prerogative. See how we went through? We went through all these things that we discussed before. Took judicial notice of all those cases. Okay? The state cannot diminish rights of the people. The assertion of federal rights, when plainly and reasonably made, is not to be defeated under the name of local practice. What was the local practice? Oh, we don't have tape recorders. Okay? No. What's the right of the sovereign? What are his rights? Whatever he says they are. Okay? So that automatically made, since it was his court, that automatically made tape recording just fine. Okay? So, but we're saying here, you can't defeat that right just because you have a local practice rule. Okay? There can be no sanction or penalty imposed upon one because of the exercise of constitutional rights. And is this a constitutional right to be a sovereign? Yes. Why? Because of the preamble. The preamble defines sovereign. Okay? All right. Republican government. So he's got a choice. He can exercise his powers of sovereignty directly or through representatives. We're choosing to be direct in our court action. Okay? This is the sovereign court. And the state of California is an inseparable part of the United States and so forth. So we go through a whole bunch of this stuff, define a court of record. A court of record is a judicial tribunal having attributes and exercising functions independently of the person of the magistrate designated generally to hold it. Why did we put that in? Because the magistrate issued a direct order denying the opposition his demurrer. He wasn't authorized to issue any orders. That's reserved to the tribunal. Who's the tribunal? The plaintiff, the sovereign plaintiff, right? Exactly. So, now, and we reach back here. What is the common law? I skipped over that earlier, but here it is. You see, the common law, bureaucrats love things in writing. Now, if you've studied your common law, you'll know that common law is not written. Okay? Now, when they say it's not written, that doesn't mean there's nothing written. What it really means is that there is no single authoritative source you can go to for the common law. Whereas with statutory law, you have a legislature to look at. The legislature created the common law. Whereas in statutory law, in common law, the common law is custom and usage since time immemorial. Okay? Well, where do you find that in writing? You know, who was it that originated the first common law? Well, there is no identifiable source. It's lost in history. Well, nevertheless, bureaucrats love things in writing. So how do you deal with these people? Well, what happened was that they came up with this Magna Carta. And after Magna Carta, when the king died, the new king came in, King Edward. And the nobility that had been responsible for forcing the king to sign the Magna Carta immediately went to King Edward and got him to sign the Confirmatio Cartarum, which is the confirming charter, which is the document which reaffirms the validity of the Magna Carta under the new king. Okay? And so in there, he gave a new order relating to Magna Carta. And basically what he said was right here. Right here, this whole thing. Our justices, sheriffs, mayors, and other ministers, which under us have the laws of our land to guide, shall allow the said charters pleaded before them in judgment in all their points, that is to wit, the great charter as the common law. Okay? In other words, translating that into modern English, what he's saying is that if the defendant wants it, he can demand that the Magna Carta be the common law, and it must be obeyed by the public servants, or the king's servants. Okay? Now, we get the common law from England as it was as of 1789. Okay? And the Magna Carta was still good back in 1789. There were changes made, but they shifted things around rather than actually changing things. And so the Magna Carta is still good law, good common law. And when you have a bureaucrat who doesn't understand something in common law, you can bring in the Magna Carta and say, this is common law, because this was what it was in 1789. Okay? So we bring this out here. We let the judge know we're bringing in Magna Carta. Okay? And there are some interesting things in Magna Carta. For example, 21 here, paragraph 21. Henceforth the writ which is called precipice shall not be served on anyone for any holding so as to cause a free man to lose his court. If you're a free man, you have your court, right? These are ancient concepts. Now, in a recent demurrer that I received from an attorney, when he had read our paperwork citing the common law, he said that was quaint. Now, my word for quaint is precedence. Okay? Well, he used that too. He said both. Actually, I think it was two different places. One was quaint and the other was archaic. But, you know, I call it precedent. Now, I don't know. Maybe precedence is a new idea to attorneys. But anyway, this is a precedent. This is a concept that's rock solid. All right, let's see. We cannot say with assurance that under the allegations of the pro se complaint, which we hold to less stringent standards than formal pleadings drafted by lawyers, it appears beyond doubt that the plaintiff can prove no set of facts in support of his claim, which would entitle him to relief. Okay? Also, an act of the court shall prejudice no man. All right? So we got some interesting authorities. All right, so the court took judicial notice of these various things. Then, the next thing the court did is we made some findings of fact. All right? And here's what the sovereign court found, as a matter of fact. The court, on its own motion, makes the following findings of fact, based upon the court record and upon the contents of the judicial notice dated May 5th, 1999. We just read that judicial notice. Number one, William Jones is one of the people, as contemplated in the preamble of the California Constitution. Second fact, the court is a court of record. And the third fact, all parties and court personnel have been properly apprised of the foregoing. Because that's what he said in his action. Okay, very simple. That's all there is to that one. Okay, that was the court, and that was signed by William Jones, Aeternatus Privatus. All right, if we look at the top of the caption here, you see Aeternatus Privatus, right? Right up there. That's Latin for private attorney. No, it's not a blanket rule. You just don't want to be an attorney representing yourself in their court. Okay? But in your own court, in this case, William Jones, it's true he's the plaintiff. William Jones is also the sovereign. And William Jones, in the capacity of Aeternatus Privatus, or private attorney, he is representing the court. Because you see, the court consists of the sovereign, the person of the sovereign, and the suit of the sovereign. Together they make an artificial, fictitious entity, and the artificial, fictitious entity has no voice. So it must have a spokesman, an attorney, to speak for it, to make commitments for it, because the court of the court is not a live entity. It's a fiction created out of two elements. One is the person of the sovereign, and the other is the suit of the sovereign. Okay? So in order to speak with the voice, you get an attorney. So a private attorney is different from a public attorney. A public attorney is the normal attorney you're familiar with. A private attorney is an attorney who does not hold his attorney services out to the public, but instead is the attorney only for one specific purpose. In this case, he's representing the court. And so he signs it down below by, okay, you'll notice it's the court that's issuing the order. It is by William Jones, private attorney. Okay? And you don't see it on here, but over on the right side, we put a real pretty gold seal. Okay? We seal it. Signed, sealed, and delivered. You've heard that? Yes.
Can you also use the term master?
No.
Repeat the question.
No. Could he use the term master? And the answer is no, because a master is kind of like a magistrate, a judge. Okay? And by the way, the magistrate can sign also, as long as he doesn't originate the order. The order has to come from the court. Because basically, the private attorney, the private attorney is nothing more than a witness to the order. Okay? That's it. That's all he is, a witness to the court, what the court did. And we put the court seal on it. That's important. So in all orders, we put a court seal. And we went to, basically all you have to do is go to Office Depot or pretty much any stationers, and you can order a corporate seal. And on the corporate seal, you can put anything you want, as long as you at least have the word seal. And you can put your name, your birth date, some phrase, you have some motto, or whatever it is, that's fine. But that is your seal. And so we take this gold seal, it's like a stamp. Some of them you lick, some of them are pre-glued, and you put it on the paper, and then you have the seal that crimps it, and you stamp it. It really looks pretty. And it also copies well, believe it or not. Even though there's no ink, when you put it on a copy machine, because it reflects unevenly, you get very good copies of that seal when you do a copy, when you use the gold. So anyway, that's the court order, okay? And this is a court making a finding of fact. Then the next thing is, this is the real meat right here, the writ of error, where we reverse the magistrate. Now, whenever you issue an order, a sovereign order, you're not a judge. See, if you were a judge, you would have a certain amount of, you might say, presence, acceptance, this kind of thing. So if you issue an order as a judge, you don't explain it, you just issue it. Oh, let me tell you a little secret. I don't know how it is in other states, but in California, if a trial lasts under, I think it's 8 hours, then you must tell the judge in advance of the decision that you want him to explain the decision. If he makes the decision first, he can ignore your request for an explanation. So you must always, you can do it verbally. I suggest you do it in writing. Okay, just a little, you can say request for explanation of judgment, something like that. But you then you let him know, and once you let him know, he's obligated by the rules of the court to make the explanation. If the trial goes over 8 hours, I think, or something like, there's some time limit, you have to look at the rules, see what it is, then you have a day or two in which to decide you want an explanation. So guess what? They try to make all these trials short, don't they? Under the 4 hour or 8 hour limitation, whatever it is. All right. However, we're not judges. We're in a very unusual position. The common law is not strong in the United States. the balance of power has been pretty well upset. So consequently, we have to lean very heavily on being right, doing our paperwork correctly, and when we make a decision, we have to explain it. And we do. At all times, we explain it. So here we have a very long explanation on this writ of error. This is a writ of error coram nobis resident. Okay? Now, there's no difference between a writ of error coram nobis resident and a writ of error coram nobis. Okay? It's just more words. Part of every lawsuit is psychological warfare. Okay? So I put this writ of error coram nobis, or QA coram nobis resident. You know why I put it there? Psychological warfare, of course. But the reason I put it there is because I knew they couldn't find it. They don't know where to look. Okay? I know where to look. I know it's valid. They don't know. I'm sure the judges don't know. Okay? So that makes them a little shaky. What's this guy got, right? That was the only reason for it. I could have just put writ of error without the coram nobis. But that's what I did. But basically all it means is that the king is there in court himself and issuing the order. That's all it means. Resident means he's resident. He's there. And writ of error, we know what that means. Coram nobis means by us, meaning our own court is correcting ourselves. And QA, I think, I forget what that is. Sorry, I looked it up and I don't remember anymore. But when I was looking up writ of error coram nobis, I saw an explanation. Just looking up writ of error coram nobis. But, of course, when you do research, you try to be thorough. So I looked up writ of error coram vobis and saw what it said to say. And it had to say that a writ of error coram vobis was like a writ of error coram nobis, QA coram nobis resident, except that it's from a higher court to a lower court. Some explanation like that. It used this phrase over in the coram vobis explanation. And it mentioned in there also that something about it was usually called coram nobis instead of all that other words. So, again, psychological warfare, okay? The court comes now to review the facts, record, and process resulting in the rulings dated February 18th, 1999. It shows that this court of record held a hearing on February 18th for the purpose of considering defendant's demurrer to plaintiff's personal action of trespass for damages. Plaintiff was present in personam, and defendant, though absent, was represented by counsel. Okay? The record shows, transcripts page 1 to 9, that the magistrate did not conduct the hearing in accordance with either the stated rules of court, Federal Rules of Civil Procedure specified in action of trespass, page 1, line 19, or the foundation rules of a court of record. You'll notice how as we go through the paper, every point that's made is cited somehow. That's what gives strength to what you're doing. You don't just make a claim. You allow the reader to go back and make his own conclusion. Okay? And, but this is what gives strength to your order. And so, let's see. Instead, the magistrate conducted his own court without notice or concurrence of the parties and without due process. In fact, at one point, the magistrate made it clear that he believed he was the owner of the courtroom. Transcript, page 2, line 20. That's where he said, my courtroom. Okay? Not satisfied with the lawful rules of court, he became a loose cannon and at some points imposed his own rules. See transcript, page 1, lines 13 to 15. 18, page 2. Okay? Page 3. Page 4. All right? So it goes. And other points, rules of another jurisdiction foreign to this court. See transcript, page 1, and so forth. So we just go, boom, we just point right at, this is where he misbehaved. In the exchange between plaintiff and magistrate, the magistrate made it perfectly clear that the fact that this is a court of record was of no consequence to him. In 2 words, so what? See transcript, page 9. Okay? Further, without proper authority, the magistrate stepped out of his function as a magistrate and by his actions and statements figuratively assumed the cloak of a tribunal. Page 5, lines, this is where he's making a decision, right? The genius of a court of record is not to be undermined. It is the birthright of every American to settle issues in a court of record if he so chooses. Throughout the transcript, the record shows that the rules of the court were not followed, that the magistrate attempted to function as a tribunal, and that the court was ineffective in furthering the goal of justice for all. You see, when you write these decisions, you've got to be neutral. You're not talking for the plaintiff. You're not talking for the defendant. You're talking right down the center, and whatever decision comes out should be based on being in the center, evaluating all facts. So you cannot be biased when you write your own judgments, and it's really best to get someone else to write the judgment for you, because it's hard not to be biased in your own cause, okay, even though you ultimately will sign it. So these failures to follow the prescribed procedures are sufficiently disruptive to the goal of providing fair justice that the court finds it necessary to issue a writ of error cui coram nobis resident as follows. The court, having reviewed the facts, the record, and the process by which the ruling was issued, and finding that the magistrate rendered a ruling by applying rules from several jurisdictions foreign to this court without leave of court, in other words, without permission of the court, and finding that the orderly decorum of the court was replaced by defective impromptu process and usurpation of legislative and court powers without leave of court. Who can make the law? Who has the legislative power? The sovereign does, you betcha. Okay? And finding that there is partial, get this now, and finding that there is partial merit in the defendant's demurrer, namely that the action, though barely sufficient, should contain a complete statement of facts upon which to grant relief, and desiring that fair justice be served for all parties, defendant as well as plaintiff. Now, therefore, the court issues this writ of error coram nobis resident, to wit, the court rescinds all rulings entered February 18th, 1999. Further, the court orders that in the interest of justice and fair play to all parties, plaintiff and defendants, and with the concurrence of plaintiff, see, he couldn't order the plaintiff, but the plaintiff agrees, okay, that the action for trespass is dismissed with prejudice if the plaintiff does not file a first amended action on or before June 8th. So what we did was we removed the magistrate's decision. We said no. We said the defendant, when he did his demurrer, had a valid point. It should have been granted. We are granting part of it, and we're ordering, the court is turning around and ordering the plaintiff to revise the action within a given specific amount of time. We gave him 30 days to revise it, which is a reasonable time in court time. That was the order. So now we set it up so that if he didn't get it filed in, then the plaintiff would be thrown out permanently, okay, with prejudice. Got that? So we were, in the order, we were as hard on the plaintiff as we were on the magistrate. We were as hard on the plaintiff as...
You came in as the plaintiff?
No, we came in as the plaintiff. Okay. Start over. The plaintiff is suing because he got hit on the bicycle. The defendant demurred and said, I don't understand your complaint. The judge said, no, we deny the demurrer. So the plaintiff still is good, right? But behind the scenes, we really had wished he had gotten rid of it, see, because we wanted to rewrite that complaint. So, but what we did, on the surface of it, we said, wait a minute. You're a magistrate. You can't make a decision. Can't make any decision. That's the prerogative of the tribunal. So we vacated his decision. It's gone. And then we said, all right, now that we vacated it, the plaintiff must file a brand new action in response to the demurrer, and the plaintiff has only so many days to do it.
So you set it up where you can win it.
No, we set it up to order ourselves to revise the action. Okay? Well, all we're doing is we're going to fix some problems, some mistakes that were made before. Okay? Yes?
At what point did the plaintiff determine that the pleading was defective?
When he got a consultant to confer with and find out what was wrong with it.
So what pleading at that point?
Because the demur had been filed. Okay? Yeah, if there had been nothing filed, he could have revised it any time. You can revise an action as many times as you want until you serve somebody with it. Once you serve somebody with it, you've triggered the process, and now you cannot amend it unless you get permission of the court. Okay?
Okay, and that's what I was asking you about mine. Do I have a statute of limitations? I have a statute of limitations?
Do you have a statute of limitations?
Yeah, on the one I filed with the federal district court, and I did not serve the defendants.
To my knowledge,
I retained a right to amend the complaint.
to my knowledge, first of all, you don't retain a right to amend the complaint because once a person is served with it,
We haven't served. Did not serve.
well, if you never serve, well, you don't have to claim the right, you just amend it.
Okay.
You know,
You have to do that within the statute.
Not under, but if I'm amending it under common law now, I'm coming back in under common law. There is no statute of limitations under common law.
that's right.
Now I understand. Yeah, okay. Declare it in the points and authorities. Okay.
See, when you're at law, there's no statutes, okay? But look, you have to pay attention to the rules of fair play. Look, what is a court? We know that the technical definition of a court is a person in suit of the sovereign. But let me give you the real definition of a court. It is a stage upon which you put a show to convince the rest of the world that the sovereign is right. Or maybe wrong. You know, let me give an example. You're in your throne in your castle, and you look out through the window, and you see somebody stealing oranges off your tree, some knave. So you send the guard out. You say, go get him. So he goes out, he gets him. You say, put him in the dungeon. Okay? Isn't that what sovereign kings did in those days? Well, that's fine, you know, that would work. But there's dungeon visiting day. And the knave's brother comes over to visit him, and he complains about how terrible he was treated, how he was unfairly thrown into the dungeon, and, you know, all sorts of claims, all right? And his brother basically believes him. He knows him. He says, well, he says, bro, he says, don't worry. He says, I'm going to take care of that for you. Okay? And so that night, the brother, who happened to be the chief cook, makes the meal, and the king is no more. Okay? Problem solved, sort of. Now, let's change this scenario a little bit. Same deal. The knave's out there. The king orders the guard out. The guard picks him up, brings him before the king. And the king says, knave, you're accused of stealing oranges off the orange tree. And how do you plead? And the knave says, I didn't do it. I'm innocent. And then the king says, well, okay, we'll have a trial. So they have the trial. And it's announced. They set a trial date. They have the announcement. The whole court shows up. Even the court jester is there. And the prisoner's brother is there. And they watch this trial take place. And all the evidence is presented. And then and if he wants, he gets a jury, and the jury convicts him. And then they throw him in the dungeon. Okay? The result is the same, isn't it? But with one important difference. And that is, come dungeon visiting day, the brother goes and visits him, and this guy complains about how he's mistreated, unfairly accused, and so forth. And the brother says, well, bro, he says, you know, you kind of earned your stay here. He says, I saw the trial, I saw the evidence, and you're where you deserve to be. I'm sorry. Okay? And the king gets to live another day. See? So that's what the court is for. Look, the king knows what happened. He saw it. The king was the victim. And the other guy who did the deed, he knows what happened. So neither one has to prove anything to the other. So you have this court proceeding to prove it to the rest of the world. And that's what a court really is. And that's why it's important that you write these papers this way and show the fairness. Be a benevolent king. Don't grab everything that you think you can. Don't do these $30 billion suits against the city of Santa Barbara or whatever. You know what I'm saying? You got to stay within acceptable limits, because remember, the whole purpose of a lawsuit is to convince the rest of the world that you're right. That's all it's for. That's the real purpose of a court. And you should take that very much into account. And there's a lot of people who do look at your records. First of all, on the first surface, there's the judge and attorneys. On the second level, there's clerks, there's newspaper reporters, there's other judges. You know, they're going to form an opinion out this. And if you have an unusual case where you're really pounding on them, you might have a lot of people looking at it. They're seeing how you handle this. So you want to get those people on your side. And you're not going to do it if you become overly demanding. You got to stay within some reasonable whatever custom and usage is, okay? Because you want that background support. Yes?
It's called commercial sanity. Commercial sanity.
Okay. Not familiar with the term, but okay. But anyhow, so, okay, going on this case. Further, let's see. Oh, we said we ordered him to file it within a certain time. Okay, and then he goes on. He says, further, the court orders that if the defendant chooses to file an answer to the first amended action, then the filing fees paid for the answer filed and the rescinded order are applied to that answer to the first amended action. For the court wills not the pains of its error on the defendants. Okay, we're just saying, look, you know, some of these courts, they actually charge you for filing an answer. And so we ordered that those fees, whatever he may have paid if he did file an answer, because we weren't sure at the time, we just said, look, these fees are transferred over to the other answer. We're not going, just because the court made a decision, it does not mean that the defendant's going to suffer further. Okay? As it turned out, we were wrong. That particular court didn't have fees for answers. That's showbiz. Anyway, at that time. I don't know what they're doing now. Okay. Further, the magistrate, plaintiff, and defendants are invited to each file and serve on all other interested parties a brief no later than June 7th, 99, to show cause to this court why this order should not take effect or should be modified. The court, mindful of the rights of the parties and the importance of fair play, will liberally construe the arguments presented. So what we're saying, look, you'll note, you remember before, the court on its own motion did these things, right? Well, when you act on your own motion, that is essentially an unfair maneuver, because nobody had a chance to defend themselves from whatever you're doing as a court. So anytime you issue any order for anything on your own motion without all parties being apprised of it, anytime you do that, you should always issue an order to show cause, which is what this really is, telling them, let us know if we're wrong. Okay? Maybe there is another point of view. Yes? When you file, all right, when you file in form of pauperous, that
how are you acknowledged as a king when you do that?
I've never had a problem with it. Okay, all you're saying, to me, all you're saying is you don't have any money. Okay? You do know that some courts may have a seal and others don't have a seal. Why? Well, I'll tell you something. Metallurgists are pretty expensive. And you have them make you a kingly seal, a sovereign seal, that costs money. And there were poor kings at times that couldn't afford such things. So courts didn't always have seals. Yeah. Microphone. Yeah, more exercise.
You mentioned in the beginning that you're still working on this. It's been over 4 years.
Yeah, this case was an intentionally slow case because we were setting up an example. We knew this in advance. The plaintiff was in no hurry. He wanted to do a perfect case where we covered everything. We were really intended to do a perfect case. We just never expected to have an opportunity to find a judge in contempt of court. That was a bonus feature.
I think I'm familiar with the case.
Yeah,
As
it's
you
on
know.
it's on the internet. Yeah. So anyway, but anyway, always, anytime you issue an order like that on your own motion or on the court's own motion, always, always, always give the parties a chance to tell you you're wrong. Just basic courtesy, okay? Okay. All right. Further, the case management conference scheduled for May 7th will be reset to a date determined by the clerk no later than September 6th unless for good cause. That phrase, good cause, is a technical, that's called a term of art. That's a technical phrase. Good cause means you better have a good legal reason. Good cause does not mean, oh, gee, you have a good, strong moral point, and yeah, we ought to be nice guys and let you have that point. No, it doesn't mean that at all. Good cause always means you better have a good, strong legal reason for whatever it is. And we set a good date so that, you know, she had wiggle room. All right. Now, you've seen the initial transcript of what the judge, you got a measure of the judge's attitude, right? And you got here's an order directly attacking the judge's order. This is a writ of error. Okay? So we got all that. Now, we very strong. We told him he usurped the judicial and legislative powers of the court, didn't he? That's what we told him. Yes, you have a question?
Bill, a question. Does this kind of a procedure work if you're involved as a defendant and you want to turn it around, if you're in divorce court,
No,
child settlement cases?
No, it only works if you're the plaintiff.
Well, I know that, but if you start off as defendant and you want to have a counterclaim, does it also work in divorce court?
Yeah, if you're counterclaiming.
Right, that's what I mean.
Yeah, you're a plaintiff, aren't you?
Yeah.
Okay, well then it works.
That's what I asked.
Yeah, but understand what is the primary point in your counterclaim is you're challenging jurisdiction. They have to prove that they have the jurisdiction. Well, if it's a divorce court, I'll tell you frankly, it kind of sounds like they do.
They already have it.
You know. Okay, see, yeah, I don't think the microphone heard that.
Oh.
Or just repeat it if you think it's...
She says that the child support is federal. The state cannot enforce child support. Well, I would say, can't the state enforce state child support laws? You say there aren't any?
Bill, as far as I know, the only ones that they issue licenses to in the state of California are citizens, not sovereigns.
Well, people can have licenses too. You just sign it. But I guess you could say you're a citizen of the United States or a citizen. Yeah.
That's all they issued. You have to claim to be a citizen and resident before they'll issue your license.
Yeah. Well, when you think about it, people don't need licenses. No, they're above the government. They're above government law. They're not above common law. If you have an accident or something, you're going to be responsible, right? If it's your fault. Failure to yield right away or something like that. There's common law rules of the road. So anyway, this here is the want to do this? Hold on a second here. Nope, we're okay, yes. There we go. Okay, now let's go to transcript number 2. All right? Transcript number 2 is the transcript of what the judge said after he found out his order had been vacated. Okay? Now let me demonstrate to you what I think you think the judge did, how he reacted. It was something like this. But instead, he calmed down. Okay? All right. So, here's the transcript. You're going to love it. You're going to love it. Bet you're wondering what this stick was for. Now you know. All right. All right, so he calls the case. We'll skip over that. Now, father of Mary Smith, the minor. Okay, all right. In this matter, it looks like to me that Mr. Jones filed, I think we resolved the difficulties from the last proceeding. An answer has been filed, and Mr. Jones filed some paperwork yesterday which was complaining about the proceedings that I conducted on February 18th. What I had to say, I don't feel there was any error. I respectfully disagree, but your paperwork is on file. You do see a difference, right? Okay. Okay, plaintiff says, very well, I'll take note of that for the record. Judge says, the big question is, what are we doing at this point? I read in there at some point, are you asking, are you going to want to amend your complaint at some time? Mr. Jones says, no. The only business before the court at this point today is making sure the defendant got the paperwork that was served yesterday. As far as barring that, there's no business before the court today. Judge says, well, there's business in the sense that we need to push the matter towards a trial or whatever's going to happen on it. That's why today is a case management. Now, you got to understand, in a case management, this is a California procedure. I don't know if they do it in other states. They probably do. But basically, what they like to do is they like to, every once in a while, have the judge look at the case and see how things are progressing. And if one party has a problem with another party, whether getting cooperation or whatever, the judge can then kind of step in and help fix things. But all a case management conference is a conference to manage the case. That's it. No decisions are made, only making little adjustments as necessary to smooth out the process. So that's what we have here as a case management conference. Still, this is an opportunity to find the plaintiff in contempt of court if he's wrong, right, in issuing those orders. Because, you know, it is kind of illegal to issue a bogus court order and pretend it's a real thing. It's, in fact, in California, it's a misdemeanor. Okay? So, see how the judge is reacting. Is this a bogus order or not that got issued, that writ of error? Okay, so he says, that's why today is a case management, says the judge. Plaintiff says, well, that's taken care of in my paperwork. It's addressed and we're to move forward. Judge says, you want a continuance? I saw a date of September in there. And he says, well, there's nothing I could add to the paperwork to make it any more clearer. It's pretty much all there. Okay? Judge says, well, and plaintiff says, well, barring that, as I said, all the business before the court is completed as of now. The judge says, well, do you want this case, I assume, Mr. Jones, and we've talked previously, but I assume you want this case to go to trial at some point. Is that correct? Yeah, absolutely. Do you want me to set a trial at this time? You see what's happening? Is the magistrate realizes he's a magistrate. He can't make a decision. He can suggest, he can cajole, he can ask, but he can't do the order. Okay? And that's what you can see it in this conversation. Now, what's interesting is the attorney, the other attorney, doesn't have a clue. You know? Every attorney goes to school, he's taught the same thing. The judge is a 500-pound gorilla, and what do you give a 500-pound gorilla when he demands a banana? Banana and anything else he wants. Right. That's what they're taught in law school. Well, he's not a 500-pound gorilla relative to the 800-pound sovereign gorilla. Okay? So, now, so do you want me to set a trial at this time? Jones says, no, I'm not asking for anything at this point in time. Well, the paperwork speaks for it. The paperwork itself is explanatory. Okay, self-explanatory. It says everything I need to say at this point in time. There's nothing that I could say to clarify it any more than what it is. There's nothing I have to add at this time, at this point in time. Now remember I told you earlier in the day that when you're in court, they do anything you want, you object. And we went through that scenario. You object. He says, why do you object? You say, that's not my wish. And then he says, if that's the best you can do, you're overruled. And you say, well, for the record, that's my objection. Okay? And so then he says, duly noted, and you move on to the next item of business. But if the judge asks you questions about your case, remember, you've done all the arguing in your paperwork. So don't fall into that trap of talking over it with the judge. What you tell the judge, it's all in the paperwork. Okay? And that's exactly what this guy did. Now, I want to tell you something. Behind the scenes, what happened here was that we prepared the paperwork and filed it in. Then the judge himself, he's asking these questions. But before we got into that courtroom, I had a meeting with the plaintiff, and I said to him, point blank, I said, why are you going to court? Okay? The plaintiff and I met in order to clarify his mind on the court, court procedures. Why are you going to court? What's the point you're going to make? You've got to do that. The night before you go to court, you must sit down with somebody and explain exactly why you're going to court. And the reason is because when you get into court, you're not going to think effectively on your feet. So you have to pre-channel your brain. And when you do that, you will say automatically the right things. And so you get into court, you talk about what's going on. You get with your friend, you talk about what's going on, what you're going to do, get a clear sense of what your goal is, what you're going to accomplish, and any deviation from that you're going to object to. Okay? And that's exactly what he did here. There was some little discussion, okay? But when it came down to it, what do you want? It's in the paperwork. Okay? I'm not going to discuss it. Okay. Self-explanatory. It says everything I needed to say at this point in time. There's nothing that I could say to clarify it any more than what it is. There's nothing I have to add at this point in time. Judge says, okay. And Jones says, and that's where, and they're kind of over-talking each other. He says, but Jones says, and that's where, at this point in time, we're done. And the judge says, and you're done? Okay. Yeah. Judge says, you want a case management conference scheduled for May 7th? Will be reset to a date determined by the clerk no later than September 6th, unless for good cause. So I'll give you another case management conference date. So the attorney says, is there some reason for that? The judge says, well, it's all explained in his paperwork. And the attorney says, well, I couldn't make heads or tails of it either, Your Honor. The judge says, well, I've talked to Mr. Jones before, and I told Mr. Jones that we have rules that well, let me explain it this way. Nobody is forcing Mr. Jones to be here. He has voluntarily chosen this forum to litigate or bring his dispute for resolution to the courts of the state of California. He is not a defendant. Nobody is trying to take property from him. He's not charged with a criminal defense. He is here of his own free will to process his dispute, which is set forth in his complaint. I have advised him. I will continue to advise him. See, he's advising him, right? Okay. Not order, right. That he has selected and elected to be here, and therefore he will have to follow the rules because he chose to be in this forum. He will have to follow the rules of the forum of the state of California. Well, now he's treading on thin ice again, see? Okay. Which includes the fast-track rules, the California rules of court, and so I've tried to make him aware of that. Now understand, he's talking to the opposing attorney. He is not ordering the sovereign plaintiff. Okay, that's how he's able to get away with that. Technically, he shouldn't be able to get away with that either, but we have a benevolent sovereign, yes.
Should he have objected?
Should he have objected? No. Well, he could have, but it didn't make any difference. No. No, we know who's boss. So, okay. Previously, we had a little dispute about that, I guess, but there's no dispute as far as I'm concerned. We have a case. I'm willing to set the matter for a trial, Mr. Jones, because that's what you want. I mean, you want somebody, and Joan says, well, eventually we'll get there. Yes, sir. And the judge says, you want me to set a trial date today or put this matter, you want a further case managed? And Joan says, there are other matters in the paperwork that have to be accomplished before. And the judge says, he wants to file maybe an amended complaint or something, and there are rules that govern that, so you'll have to follow the notice procedures and things like that. And the attorney says, I want to clarify, it's not the order? And the judge says, no, you know, and I'm going to allow him to do this, and I'm going to, you know, if he wants, you know, we had a dispute about the tape recording. If you properly come to me under Rule 980 of the California Rules of Court, and there's a procedure set forth in there that you can request to do that, but, and Joan says, well, I was under, at that point in time, I was under previous interpretation of that rule. However, and the judge says, I'll direct you to that, and if there's a problem, I don't want to have, you know, I just want you to know that where I'm coming from. I know where you're coming from. I've dealt with these problems and this type of, you know, I understand a bit where you're coming from. I respectfully disagree to some extent, but that's okay. Do you detect a difference from the other transcript? But nobody's forcing you to be here, and so you're kind of, you're in the driver's chair as far as processing the lawsuit. And Joan says, I understand that. The judge says, do you want to come back for further case management? How about on a Friday in August or any day of the week in August? Joan says, well, there's some other things I wish to accomplish that are listed in the paperwork, and at that point in time, I'll move forward. All right, you want to come back, you pick a day in August. Well, I have no date in mind at this time. Okay, can I pick one? I'm going to pick a date that you have to come back. He says, well, he says, that's the way it runs, Mr. Jones. He says, very well. That's the way it runs, the judge says. So Jones says, however, I will object for the record. See, he was a little lost, too. He shouldn't have objected. He should have just fine, you know. The points were made, weren't they? Okay. Okay, the judge says, that will be in compliance with the fast-track rules, and I will set it for dismissal. And when you don't show up for that, your case gets dismissed. And Jones says, as I said, and the judge says, that's the rules. Well, now you know. You volunteered to be here, so the system can voluntarily on its own throw you out of here. It's your choice. I mean, I'm not here to argue with you today. And Jones says, well, I'm not here to argue today either. The paperwork explained my process, the direction I'm going, and there's nothing else I can say. Okay, further case management, Monday, August 16th, 8:30, this department, 666. I asked that the defendant give notice, written notice, okay? And the reporter says yes. Jones says, thank you very much. The attorney says, that date again? And the judge says, August the 16th, 8:30, 1999, 8:30 a.m., this department. The attorney says, okay, am I correct in that the court made no ruling on this apparent request to amend the complaint today? The judge says, well, I've made no rulings. I've made, well, what I've done, the record speaks for itself. And notice this. It doesn't matter what the judge says. The attorney says, thank you, Your Honor. See? They always say thank you. Tomorrow I'm going to cut your attorney head off. Okay? Thank you, Your Honor. That's what they do, right? There it is. So that was the transcript. Did you notice a difference? Of course you did. So, all right? So then what happened was the plaintiff put together the first amended action, and then the judge came along to the clerk and said to the clerk, told the clerk to put in a request to the court to have the action, the first amended action, rejected. The clerk then did that. The judge received it and then ruled on it to be rejected. So that's what eventually led to the contempt of court citation against the judge. So, but the supervising clerk who filed that certificate and order vacating documents, look what she said on it. we have an actual quote of it. So the green lettering denotes information entered on a pre-printed form. So you have the black is the pre-printed form, and then the green part is what got written in by hand. Okay. I, the county clerk and ex officio clerk of the Superior Court of the State of California for the County of Calamity, do hereby certify that the first amended action of trespass and trespass on the case, which was filed on demand, was filed in the above entitled action on June 7, 1999, that the documents was or were filed in error, as the court directed said clerk to reject the above document, as there is no leave of court or stipulation from the other party to file a first amended complaint. See, she says it right there. The court directed her to do this. That was a smart clerk. She kept her, it was a CYA. Then the judge came along, pursuant to the certificate of the clerk in good cause appearing, is hereby ordered that the first amended action of trespass and trespass on the case be hereby vacated. So she was ordered to put this in, she put it in, and then the judge ordered it thrown back out. Well, he obviously forgot his lessons. So, what we did, transcript number 3. Now, you have to understand that we couldn't read the signature. So we didn't know exactly who signed it. Of course, we had a pretty good idea, you know. But still, we didn't have that positive, total 100% proof. So what we did, transcript number 3, a hearing was held. Let's see. There were certain admissions. We'll go to transcript 3. Here's the Superior Court again. Jones versus Smith. Good morning, all this stuff. Low shark net for the defendant. That was an attorney. Okay? Okay, so they respond, they call a counter. Okay. So the judge says, all right, this is here on, I don't know what this is. I just don't accept paperwork, Mr. Jones. And Jones says, well, it's pertinent, Your Honor, in a future issue. Okay, it'll be placed in the file. Did you get a copy of it? I think what he did is he actually manually gave the judge some paperwork relating to this contempt. But anyway, did you get a copy of it? Mr. Jones says, not yet, sir. I'm a little confused myself, who's who, what's doing. But anyway, he says, you're required to serve him before I can accept it. We have it right here. It can be served right now, he says. Well, serve him with it. Thank you. Now we'll place it in the file. Okay, so Jones handed it over to the attorney. All right. Judge says, okay, what do you want to do today? Do you want to set a trial date? Jones, not at this point in time. There are some administrative procedural issues that have arisen that I need to do before proceeding. I'll do forthcoming. However, there are a couple of questions I'd like to ask. Judge says, well, let me remind you again, I can't give you legal advice. I indicated that the last several occasions that some of the questions I may be able to answer, some I can't. Okay, very well. Could you give me your full name, Your Honor? My full name? Yes, please. You can look it up, Roy Stephen Legume, or Legume. Roy Stephen Legume. Does everybody know what a legume is?
A vegetable.
Yes, what kind of vegetable? A bean. Roy Bean. No, Judge Roy Bean was the hanging judge of the Wild West.
Oh, was he? Oh.
Yeah. Okay.
Is that really his name?
No, we just made it up. The names were changed to protect the guilty, remember? Okay. Anyway, so this was Judge Roy Legume. All right. So he repeats it. Mr. Jones says, Roy Stephen Legume. The judge says, Stephen with a PH. Thank you very much. I use my middle initial, though. Mr. Jones says, do you or anyone you know of at this time have a claim against me? The judge says, a claim against you, me, or anybody? I don't know what you're doing here. What we're doing, playing 20 questions? Mr. Jones says, these are questions I need to proceed on with the procedural administration issue. Now, I have no claim against you, Mr. Jones. I didn't know who you were until you walked in this court as a plaintiff. Okay, very well, thank you. And do you know whose name is signed on this? And he shows him that certificate, you know, the order. And the judge says, well, that's mine. That's your name? Very well. Thank you very much. Judge says, that's why I vacated. Well, the clerk erroneously filed your first amended cause of action. You did not ask for leave of court to do that. You have to do that or get a stipulation with the other side agreeing. And Jones says, I understand that. But maybe they'll agree, says the judge. But I vacated the order because the clerk erroneously did that. Mr. Jones says, yes, for the record, I wish to enter an objection. That's all I have to handle at this time other than setting a new trial conference, trial readiness conference day. Judge says, when would you like to do that, sir? 60 days would be fine with me. And the judge says, well, let me hear from the other side. And the attorney says, well, as far as we're concerned, we have a motion pending to compel a deposition on the 30th. After the deposition, we're ready to go with trial or arbitration as the court sees fit. Now, by the way, speaking of depositions, whenever you do a common law lawsuit, you've got to provide all the evidence up front. Okay? All the paperwork, all the medical paperwork, whatever it is, if you have evidence, you provide it right up front. That gets served right with your lawsuit. When you have a common law lawsuit, there is no such thing as discovery. Why? Because there's nothing to discover. You've served it all. You can tell them to go fly a kite. The only remedy that a defendant has, if you refuse to provide the evidence, the only remedy he has is to make a motion in limine asking the court to block out all the evidence, not all the evidence, to block out the evidence that has not been presented, to avoid trial by surprise. So that's his only remedy. Well, in a common law suit, you've provided all the evidence. You don't care if they block everything afterwards. There's nothing more to present. Okay? They don't understand that. And they go through all sorts of gyrations because you won't cooperate. Which is fine. Runs up their costs. Okay? Remember, lawsuits, as I said, it's civilized warfare. I've said it's psychological warfare. It's also a war of attrition. Run their costs up. The higher, the better. Okay? At some point, they're going to decide maybe it's not worth it. Maybe they ought to settle with you. Okay. So continue on. As far as we're concerned, says the attorney, we have a motion pending to compel deposition on the 30th. After the deposition, we're ready to go with trial or arbitration as the court sees fit. The judge says, well, Mr. Jones wants another case management conference, and maybe the other side will agree you can file your first amended complaint. Mr. Jones says, sorry, could you speak up a little bit? Sure. I said Mr. Jones wants a continuance of the case management conference, and so I'm going to do that because he may want to file a motion to file his first amended cause of action, or he may want to see if you'll agree that he can file it. I don't know, but that's the way these things are done. If you want to do that, I don't know if you still want to do that. But there are some other matters apparently relating to the depositions and stuff, so I don't know what that's all about. But Judge Simmons will be hearing it. And yeah, that had to do with deposition stuff, so that was a separate thing, which I did not include in the file. But, okay. Anyway, the rest of it is kind of normal stuff. I mean, the judge basically is getting back to thinking he's in charge. So let's see. We'll go down a ways here. They settle. They get a new date, new hearing date, and so forth. So the whole purpose, what was the goal? It's getting warm. I guess the whole goal of today's hearing from the plaintiff's point of view was to get absolute proof who signed that order. Okay? And we got the admission, right? Okay. Now we go to the next thing, which is the order sealing of papers. Now we had this little problem. We did not want the opposition to see all of our strategy. We didn't really want them to fully appreciate the strength of the sovereign. And we had a little problem with the judge. Well, now, the judge is not a defendant. He's not a party to the action. He's kind of offline. So we invoked, by sovereign prerogative, we invoked one of the code's provisions that says that all meetings must be public except meetings that deal with health issues, you know, personal health of people. Your medical records are private. And the other thing is personnel issues. In other words, when there's a meeting to decide how to discipline a public employee by a public supervisor, that meeting is private. That can be private. They're permitted to have those private meetings. So what we did is we took the position that the judge is a public employee and we have a disciplinary problem. And because of that, we could operate on this issue in secret. And so we put in an order sealing the papers. See? All right, now what we did was the top sheet contained only the who versus who information, the normal caption. There was no text on the first page. We took the remainder of the case and a copy of the first page and put it inside an envelope, and we put the first page outside the envelope and filed it that way. Okay? So it was sealed. Okay, so here's the order sealing the papers. Are you starting to catch on to the flexibility of the sovereign? Okay, this is really I mean, this is fun stuff to read through in certain ways, but what I really want you to get out of it is that you are boss. Now, you've got to put on a good image. You want to follow procedures, but you don't want these guys to get away with stuff either. And so you want to be able to adjust to the situation as it calls for. All right, here's the order sealing papers. You can see what it looked like there. The court comes now to find that the matter before it is a personnel matter requiring the court's protection of the privacy of the persons herein named. The attached envelope containing papers pertaining to personnel matters is hereby ordered sealed. It may be opened only by this court or by the following persons. I hold the filings, that's the clerk. Roy Legume, that was the judge, or William Jones, that's the plaintiff. This order to seal may be countermanded either verbally or in writing, temporarily or permanently, at any time in or out of court session by I hold the filings and Roy Legume, acting in common agreement between themselves. Okay? So we say, look, you guys, if you want to make it public, we're not going to stop you. I agree. And so, what's in the envelope? Well, a notice of motion, a motion for contempt, affidavit of William Jones, and affidavit of a witness. We had his actual name, of course. A copy of the caption page of each paper must be attached to the outside of the envelope. Okay? The court. Witness the seal of the court, this 27th day of September, signed by William Jones, private attorney. This time we used English instead of Latin. Instead of attornatus privatus, we said private attorney. Means the same thing. And we put the seal on it over on the right-hand side. A gold seal, because it's an order. All right, so that... I don't know. I don't know. It doesn't matter. Who's it? Let me ask you this. Who's the sovereign? Who sets the rules? Who decides which side of the page is the best part? Yeah. That's right. Okay. So we had a notice of a motion for contempt, confidential personnel matter. Okay? And that's what we called it. So here's the cover page. We said, notice of motion for contempt, confidential personnel matter. To all interested parties, please take notice, and so on and so on. We say where, Department 666 of the above entitled court located at 1313 Bastille Street, Megalopolis, California. Okay, so on. It was actually in San Bernardino at their main courthouse. All right, then we have the motion for contempt. Now, contempts operate a little differently. what you do is you have an affidavit which says, here's what happened, and then you ask the court for contempt. And if they don't answer the affidavit, it's presumed true, right? Okay, so that's basically what that's about when you make that motion. All right, and so we made a motion. There it is. Comes now William Jones and moves the above entitled court. And then we space down, and the remainder of the page is filled in order to force information on the next page. Why? Because this cover sheet goes on the outside of the envelope. And those little hash marks you see there, or those slants there, that's so to fill the page. That's how you fill a page. You put 10 of those, and that uses up the empty lines. Okay, that's the normal way of doing things. And then it says here, comes now William Jones and moves the above entitled court to find I hold the filings, the deputy clerk of said court, and or royal legume, a magistrate of said court, to be in either civil contempt or criminal contempt or both, but not in misdemeanor contempt of the above entitled court. There's 3 kinds of contempts in California. You can have a civil contempt, you can have a criminal intent, or you can have a misdemeanor contempt. Misdemeanor contempt means jail time. Criminal contempt doesn't necessarily mean jail time, okay? So you have 3. So what you got to do is basically you've got to make your accusation with the affidavit, and you make the motion, and we explain it's a personnel matter. When you can go on the website 1215.org, and this case is on there, so you don't have to wait if you want to read the details. So I'm going to skip over these details, okay? And then you have the affidavit of the witness saying exactly what happened. All right, then we had the contempt hearing. And we scheduled the contempt hearing for the same date that we had some other hearing with this judge. So he's being judged, he's on trial for contempt, and he's sitting on the bench because he's not the tribunal. See, I don't care if we have a good judge or bad judge, frankly, because any order he issues, I'm going to vacate. Okay. Transcript number 4. This is the contempt hearing. Let's see, I guess we'll get down here. Okay. Okay, Mr. Jones there, fine. Judge says, I don't see the other side, I guess. For this side, this issue doesn't concern the other side. Well, everything on the case concerns the other side. Jones says, okay. And the judge says, and they should have been noticed, really, but that's okay. Well, what other hearings? This is on your motion to have, I guess, myself and I hold the filings. Who is one of the supervising clerks to be held in contempt? That's correct. And the court read, you're the moving party, moving papers and your statements, and I have all these documents in the file, and I did some research on this yesterday. Do you have anything you wish to add, Mr. Jones? That's a trap. Okay? That sucks you in. Mr. Jones said, the only question I have at this point in time concerns Ms. Filing's certified document where she states that she was directed to do what she did. My question would be, who is the entity that ordered her to do so? Earlier we got that he had signed it, right, but we don't know who talked to her and told her to put it in the first place. So my question would be, who is the entity that ordered her to do so? I do not know who that would be at this time. Well, if you looked in the file, there's a certificate in order of vacating documents which says filed June the 9th, that I signed on June the 9th, that bears my signature, and it's in the file too, okay? And Mr. Jones says, well, you're the entity who directed her to do what she did? See, he tried to dodge around it. He stayed on point. Why did he stay on point? Because before he went into that courtroom, we reviewed exactly what he was there for. That's what helps you to stay on point. Okay. I said, says the judge, pursuant to the certificate of the clerk and good cause appearing, it is hereby ordered that the First Amendment action of trespass on the case is hereby vacated. Jones says, okay, I understand that aspect of the certification, but she states that she was directed to do so. Uh-huh, says the judge. And Jones says, well, I wish to know the entity that directed her to do that. I did. I just said I did. The California Superior Court did. State of California. Jones says, well, that's the only point I need to clarify at this point in time. in and for the County of Calamity. The Superior Court by myself, in and for the County of Calamity. It's right in the file. Jones says, well, I didn't see that the way it read. That's my inquiry. Anything you wish to add, says the judge? No. If anybody else has anything to say in the matter. The judge says, well, I do in terms of ruling. Oh, okay. California, says the judge, and I've spoken to you before about, we may have a difference of legal opinion here, but I've spoken to you before about the fact that you brought the lawsuit in the state of California Superior Court, and that you would therefore, because nobody is compelling you to utilize our facilities, but you have chosen to file the lawsuit against the people who you had a traffic accident, allegedly had a traffic accident with some time ago. And, okay, now, anyway, he says, Jones says, excuse me, would you speak up a little bit? Yes. I hope, and by the way, that's a technique, psychologically, to gain control over the other person. Okay? It's subtle, but it is a technique. Okay. Okay. Judge says, yes, I hope you don't have a tape recording going again, Mr. Jones. No, I haven't. And judge said, well, I don't care. You have to ask. No, I'm asking because I cannot hear you. If you do, I'll consider your question. I don't care, frankly, but you have to ask. And the rules of the court, and I told you before, and that's what I'm trying to inform you of now. You've chosen this as your forum to bring the business dispute into. And when your lawsuit, your litigating is in the Superior Court, I notified you previously that I'm obligated because of my position, because you brought the lawsuit utilizing the Superior Court of the State of California, and nobody is compelling you to use this forum. I'm telling you that. And I've told you previously that the rules have to be followed as established by the California Judicial Council and the California State Legislature. When they adopted the California Code of Civil Procedure and those rules that govern our proceedings in the trial court, California Code of Civil Procedure, Section 1209, that's 1209, provides a list of acts or admissions which constitute contempt. Section 1209 in no manner allows for a court to hold itself in contempt on the motion of a party to a case being heard by the court. Now, he's right. A court cannot hold itself in contempt. But the judge is not the court, is he? See? But you see how he's trying to slide out of this one. Another thing I want you to notice. We must have something here, because why is he spending all this time discussing this? If he were really in charge, he would have just thrown us out. Right? So that's just another little aspect of it. Okay. So let's see. Additionally, you have failed to claim that the clerk or holder of filings committed any of the acts or admissions that constitute contempt under Section 1209 of the California Code of Civil Procedure. Therefore, your motion is entirely devoid of merit, and I so rule and deny the motion. So Jones says, well, okay, well, for the record, I object. Judge says, I understand that. Okay, says Jones. Okay. Judge says, all right, I don't know when the next court hearing is, Mr. Jones. Well, at this point, there's a CMC scheduled for Monday. Monday, okay. And so he gets a transcript from the gal, and that's that. Okay? So that was the transcript. So he established in the one hearing who signed it. He established in the second hearing who ordered the clerk. All right? And we've now had the hearing, haven't we? Now comes the ruling on contempt. Now it took us, see, from October 14th to February 2nd. So you can bet we researched this. We covered a lot of territory. And here's the ruling. You're going to get a laugh out of this one. You'll see. All right. Here it is. I think this will help me a little. Okay. All right. Comes now the court to review the law, the facts, and the record, and to rule accordingly. Summary. Oliver Wendell Holmes once wrote, I long have said there is no such thing as a hard case. I am frightened weakly, but always when you walk up to the lion and lay hold the hide comes off, and the same old donkey of a question of law is underneath. Through unplanned circumstance, duty falls upon this court of record to lay hold of the lion, unhide the underlying question of law, and do what is necessary to preserve the rights of the parties to orderly due process and the good conduct of the business of this court, and to vindicate the authority and dignity of this court in the face of an apparent modern palace rebellion. You know, it's fun to write some of this stuff. The question before this court is whether acts of the accused persons are contempts of the authority of this court. According to the moving party's affidavit, the accused understood, or should have understood, that the court expected that the plaintiff would file a First Amendment action. According to the moving party's affidavit, the day following the filing of the First Amendment action, the accused conspired to remove the paper, and did remove the paper, from the official court records. The moving party requests that this court invoke its contempt powers to preserve the rights of the parties to orderly due process and the good conduct of the business of this court, and to vindicate the authority and dignity of this court. Remember, that's what contempt is all about. Dignity and authority of the court. No objection as to the sufficiency of the affidavit was presented to this court during the fact-finding phase of the trial. During the conclusionary phase, the magistrate did opine his own personal view. However, an objection was raised, and the objection was not overruled, but sustained by implication. Okay? He objected, didn't he? The plaintiff objected to the court's ruling, the judge's ruling, but the judge never came out and said, "You're overruled." Okay? He just said, "I understand that." Remember that? He said, "I understand that." So he did not contradict the plaintiff. Remember, in the backyard, the last kid who speaks wins. Okay? So the last significant thing said was that he objected, and the judge concurred. The judge said, "I understand that." Okay. So there was no objection to the sufficiency. And of course, you see all these links here. These are footnotes that were on the actual paper. Okay, where we cite certain, transcripts and that sort of thing. Okay, so sealing. Although the contempt hearing is held in open court, the papers of this personnel matter are ordered sealed to protect the privacy of the subject persons. The ruling may be either verbally or in writing ordered unsealed any time in or out of court session by Roy Legomé, William Jones, or any court of record. On October 14th, 1999, the motion for contempt presented by William Jones came before the above entitled court of record. Present were Roy Legomé as respondent and William Jones as moving party. Roy Legomé also presided as magistrate. I hold the filings did not appear, although she had been served notice. The following is organized into 4 sections: judicial cognizance, findings of fact, discussion and conclusions of law, impeachment and penalty. Now, the judicial cognizance is different from judicial notice, remember? Judicial notice, you take facts into account, you kind of work it into the judgment. Some apply, some doesn't. That's what you consider. Judicial cognizance, it's obligatory. It must be part of the decision. The decision must be in conformance with whatever you're taking judicial cognizance of. Okay, judicial cognizance. That is, straight out of Black's Law Dictionary, judicial notice or knowledge upon which a judge is bound to act without having it proved in evidence. It is the public policy of the state that public agencies exist and so forth as the people do not yield their sovereignty. That's that, okay? And so there's that. Laws are organic, ordinary, either written or unwritten. A written law is that which is promulgated in writing and of which a record is in existence. The organic law, let's see. Any judicial record may be impeached by evidence of a want of jurisdiction of the court or judicial officer, of collusion between the parties, or fraud in the party offering the record in respect to the proceedings. Does that apply to this? Sure does. Then we go into sovereignty, what the meaning of sovereignty is. The people of this state have rights by their own prerogative. Declaration of rights may not be construed to impair or deny others retained by the people. So forth. So we're backing this up. And this whole section is on the law on the various rules, laws, definition of court of record. We build the whole picture. This contempt ruling in your cases, when you put together your cases, is a tremendous resource where you're trying to lock down your sovereignty. It's all right here. This is as complete as you could get. Okay? So I suggest that you really study this particular section. Okay? It's called Judicial Cognizance, Section 1 here. So we went over a lot of that stuff, so I'm going to skip over that and just go down to the further down. We do get into contempt. I think it's important that you see 1209 contempt, right? Now he said that a court cannot find itself in contempt. Now obviously he's trying to slide under the protection of that claim. But here's what the actual code says, California Code, and which we decree to be, right? Judicial cognizance. So we're saying this is the law of the case, basically. And look at Section 3 of that code, 1209. Misbehavior in office or other willful neglect or violation of duty by an attorney, counsel, clerk, sheriff, coroner, or other person appointed or elected to perform a judicial or ministerial service. They wouldn't come out and say judge, would they? Right. So you see, it's right there. I'll tell you, when I read these codes, there's a marvelous consistency among them. Somebody's got brains. Somebody understands this stuff. You can see it in how these codes fit together. So one of the things I knew about the creation of these codes is that the legislature passes this information over to the law review or the legislative review department. And there they're loaded up with attorneys, and they review these things for consistency and so forth. So as I studied it, I homed in on the idea that there were three groups of people who really understood this sovereignty thing. And they were the legislative committee that reviewed the creation of these things, not necessarily the other committees that are creating them, okay, but the legislative committee. The other was the judges of the Supreme Court and the appellate courts, and the third was accidentally people like you and me, okay? That's what I kind of figured out. So one day I was sent on a mission up to Sacramento to do some legal research. And I said, heck, while I'm there, I'm going to stop in on the legislature and talk to some of these guys in the legislative committee. Okay? So I went in there in the law review committee. I went in there, and I happened to be lucky, and I got a hold of one of the supervisors there. So I managed to capture 5 minutes of her time. She was very, very polite, very nice lady, and she was an attorney, and she was a supervising attorney. So I sat down, and I started asking her some of these pointed questions. Well, in about 10 seconds, I figured out I had reached a well of ignorance. Okay? This lady didn't have a clue. So that immediately changed my approach. I thought, you know, here I was hoping to really kind of pick some brains, and there was nothing there. Okay? And so obviously I changed my whole direction. So I said, well, explain this process to me. What happens? You know, you get a law that's proposed, and it comes over into your committee. What happens then? How do you consider it? I didn't tell her the part how I noticed this consistency and how they, you know, seemed to understand that. I knew I was lost on that point. But what happens? And she says, oh, he says, well, what we do is we have a meeting with the Supreme Court, and they review it, and they look at it and give us suggestions. So that narrowed it down to one group up there. Only the Supreme Court justices really understand this whole thing. The attorneys, with their defective schooling, don't. And they're hired into the legislature, but it's the judges that are keeping this system straight. And they're doing an excellent job, I think. I mean, they can't control all the bad laws that come through, but they can certainly control through suggestion, and it's a powerful suggestion, the inconsistency, okay? And they do a good job of that. And so here it is. Here's an example of one of those keeping it straight. They wanted to protect the judges, but they didn't really want to let them off the hook. Okay? They did not want to destroy the other system. We are the other system. And so what they did is, rather than say a judge outright, they just said, or other person appointed or elected to perform a judicial or ministerial service. Well, the average guy reading this would, it gets heavy reading to read this stuff, and you could miss it easily. Okay, so skipping down past that, there's other codes here and so forth. All right, now we had a finding of fact. The court finds the following facts to be certain. Plaintiff had leave of court to file a First Amendment action. Failure to file a First Amendment action by a date certain would result in forfeiture of plaintiff's right of recovery with prejudice. Remember, there was an order. He had to file his First Amendment action by a certain date or forget it. Well, that's what this is. We find that this is true. The magistrate and parties were duly notified of plaintiff's leave of court and were given 33 days in which to show cause why the order should not take effect or should be modified. The magistrate and the parties remained silent. By their lack of action and lack of objection, they tacitly agreed with the order. A First Amendment action was filed in the court on June 7th. The deputy clerk of this court, by her own certified admission, see, it's certified. Certified records, you know how it is that you get, if there's something, you have to have an affidavit. But the government does not produce affidavits. They produce certified somethings, whatever it is. That's the governmental equivalent of an affidavit. So, anyway, we have on this government document her admission. The deputy clerk of this court, by her own certified admission, did not collude with the magistrate. However, she did accept, via undue influence, the magistrate's unauthorized redirection of her duties, which resulted in the vacating of the plaintiff's First Amendment action. Now, here's something else I want to point out. When we were making the motion for contempt of court, we were wearing the plaintiff's hat, the injured party's hat. So we went hell-bent for leather, right? We're out to slash anybody. They're guilty. They did this, blah, 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 okay? Because when you are the plaintiff, even though you're trying to be fair, you are an accuser, you're in an accusatory mode, and you do make some very strong statements against the opposition. That's to be expected, right? Okay, but this is different. This is now, he took his plaintiff's hat off, and he put on his tribunal hat. And you're writing this, and now you have to go down the center of the road. And so we're looking at this, and we're saying, well, the clerk wasn't really that bad. What really happened was, no, she didn't collude. What happened was she got ordered, and this type of thing. So this is writing, the style of writing here is now toward the center. That's what I want you to notice, okay? That is to say, her will was overpowered, and she was induced to do an act which she would not do if left to act freely. She was deprived of free agency so that her will was replaced by the will of the magistrate. Specifically, she says that the court directed said clerk to reject the above document. And because of that, quote, the said clerk petitions this court that a order be made vacating, which in turn leads to the order that, quote, pursuant to the certificate of the clerk in good cause appearing, it is hereby ordered that the First Amendment action of trespass and trespass on the case is hereby vacated, end quote. Removing the clerk from this anomaly of logic, we are asked to believe that because the court directed the rejecting of the document, the court then ordered the document vacated. Because this court did not direct the clerk to reject the document, right? It wasn't this court. It was a judge doing something. Okay? So we never lose sight of the fact who's the court and who's the judge and so forth. And because there was no notice and no hearing on the matter, this is an attempt to commit a fraud upon the court under color of law. Okay? The magistrate of this court, by his own admission, directed the clerk to reject the First Amendment complaint. And you see these like Note 12 and Note 13. We're citing back to We're citing back to that transcript or whatever. Okay? Then the clerk submitted her certificate. The magistrate, by his own admission, without the benefit of notice to the parties or open court or hearing, signed the order under color of law vacating a First Amendment action previously authorized by order of this court. Though also by his own admission, he has no claim against the plaintiff and knows of no one who does have a relevant claim against the plaintiff. Remember when we asked that question back there? Yeah. Do you have a claim against me? That's another important point. Sometimes you just say, do you have a claim against me? He says, no, you can hold it against him later. The magistrate is a person appointed or elected to perform ministerial service in a court of record, because all judicial functions in a court of record are reserved to the tribunal, which must be independent of the magistrate. The magistrate of this court has usurped, that means grab control of, right? Has usurped the independent powers of the tribunal of this court of record by making discretionary judgments which are reserved to and should have been made by the tribunal independently of the person of the magistrate designated generally to hold it. And we have another note referring to the definition of a court of record. The magistrate of this court, by his own admission, antecedent to any hearing by the court or notice to any of the parties under color of law, usurped the authority of the court and directed the clerk of the court to reject the first amended action. The magistrate of this court, by the way, I want you to also notice in this style, you notice that we get a little bit repetitive? Yeah. You should avoid, to some degree, pronouns, because pronouns tend to lose the meaning. So instead of using the pronoun, we use the actual name, or instead of referring to some action, we repeat the action. This pounds in the idea. That's what that's all about. We're pounding in, this is what happened, over and over again. So that's the reason for that style. Hopefully you're learning a little bit about how to write in this. Okay. So, discussion and conclusions of law. I think we're approaching the big laugh here. On October 7th, William Jones filed an action of trespass for damages. The opening sentence decreed, this is a court of record. In defendant's demur and later his answer, there was no objection to the court being a court of record. Nowhere in the record is there any objection from magistrate or defendants regarding this court being a court of record. On May 5th, 1999, this court determined that William Jones is one of the people as contemplated in the preambles of the Constitutions. This court is a court of record, and all parties were properly so apprised. Building on that, the court issued a show cause writ of error. Throughout the writ, the concept of a court of record was asserted. The magistrate, plaintiff, and defendants were each invited to file and serve on all other interested parties a brief no later than June 7th to show cause why this order should not take effect or should be modified. No objections or briefs were served or filed. The magistrate and parties, by their lack of action and lack of objection, tacitly accepted the writ and its supporting papers. Now, I have to tell you something else. 100% of all the orders to show cause I've ever issued have gone unanswered. It's an interesting little thing. If you fail to object, it means you agree, right? That applies to the other side, too. It is the design of our systems of jurisprudence that courts have no jurisdiction until a party comes forth and declares a cause needing resolution. Yeah, judges have no authority until somebody files a lawsuit. That's what we're saying. The particular jurisdiction depends on how the cause is declared by the plaintiff. Jurisdiction may be administrative, at law, in equity, or any of many other formats. In this case, the jurisdiction is at law in a court of record under the sovereign authority of one of the people. It is essential to understand what are a sovereign, a magistrate, a court, and a court of record. A court is the person in suit of the sovereign. Who is the sovereign? It is the people, either in plural or in singular capacity. In singular capacity, in this case, it is William Jones, one of the people as contemplated in the preambles of the 1849 Constitution for California, the 1879 Constitution for the state of California. You notice that? There's a difference between California and the state of California. And the 1789 Constitution for the United States of America. Notice it's not of the United States of America, because that's exactly what it says in those preambles. California, the state of California, and the United States of America have no general sovereignty. Theirs is eclipse sovereignty. Whatever sovereignty they have is limited to their respective constitutionally defined spheres of control. The general sovereignty is reserved to the people without diminishment. Lest that be forgotten, the California Government Code twice admonishes the public servants that the people of this state do not yield their sovereignty to the agencies which serve them. Further, when the state of California did attempt to diminish one's rights, it was determined that the state cannot diminish rights of the people. That was the Hurtado case. Okay? It is by the prerogative of the sovereign whether and how a court is authorized to proceed. In this case, the chosen form of the court is that of a court of record. This court recognizes the good work of the legislative and judicial branches of the United States of America and has adopted the Federal Rules of Civil Procedure as its own rules. This is compatible with the choice of the California legislature, which expresses its will through the California Code of Civil Procedure, Section 1897, which states in part, quote, "The written law of this state is therefore contained in its Constitution and statutes and in the Constitution and statutes of the United States. The state of California itself recognizes the validities of the laws of the United States of America and it adopts those laws as its own. A qualifying feature of a court of record is that the tribunal is independent of the magistrate appointed to conduct the proceedings. The magistrate is a person appointed or elected to perform ministerial service in a court of record. His service is ministerial. And listen, you're welcome to use all of this stuff in your own lawsuits when you're establishing your sovereignty and you're writing your judgments or rulings or whatever. This is powerful stuff. I want to...
Did you ever correct this? Because I had trouble getting into this section.
You had trouble getting into this?
Yeah.
On the disk or on the website?
Website.
I didn't know there was a problem. I'll go check it out. Okay. All right. In this instant question, the magistrate unduly chose... Unduly. What does the word duly mean? Duly means it meets the requirements of both the common law and the statutory law. Or put another way, it meets the requirements of both substantive requirements and form requirements. So we're saying he was unduly, meaning he didn't meet all the requirements. Okay? So, where am I here? I lost it. Oh, there. In this instant question, the magistrate unduly chose to personally bypass all procedure, direct the court deputy clerk to reject the First Amendment action, and then sign the accompanying pre-printed order without proper hearing or notice to any of the affected parties. That exceeds the jurisdiction of a magistrate who only possesses ministerial authority, separate from the authority of an independent tribunal of a court of record. On more than one occasion, the magistrate, you're going to love this, has indicated his preference for California rules. So be it for his cause. This court, for purposes of accommodating the accused's choice of law, adopts the California Code of Civil Procedure as it relates to contempt of court. Let there be no doubt as to the justice of this proceeding for the accused. You see what happened? The king said, suspend this law, bring this law in, and now it's a go.
So you brought his law in?
The king brought in the choice of law that the defendant, the accused, made. The judge over and over and over again cited California law. It was his preference.
And even 1209.
Even 1209. Let's go right here. On more than one occasion, the magistrate has indicated his preference for California rules. I'm going to click on that. Note 34, Plaintiff's Exhibit 15, page 4, line 17-18, page 5, line 17-19, and transcript, October 14th, page 4. We've nailed him. Okay? Isn't that cute? Again, get this through your head. You are the boss. What you say is law. You decree the law. But only if you're the plaintiff. Only if you're the counter-plaintiff. You cannot do any of this if you are the defendant. Okay? You've got to flip your status out of defendant status into plaintiff status. And you do that with a counterclaim or you do that with a habeas corpus. All right? That's the key. It's your court. And a court of record is the form specified by the California Constitution. Hands down. It doesn't say maybe. It says they are courts of record. Okay? All right. So, California Code of Civil Procedure, Section 1209, provides that acts in respect to a court's proceedings are contempts of the authority of the court. If a person who is appointed or elected to perform a ministerial service misbehaves, neglects, or violates a duty, or if a person falsely pretends to act under authority of an order or process of the court, or if a person disobeys any lawful judgment, order, or process of the court. Now remember, we had an order saying that the plaintiff could file a new amended action. Yes, sir.
If you filed a order to dismiss as a defendant, how does this come in play?
Well, all right. Now that order that you are defendant. Yeah, we'll repeat the question. That order that you're asking about, where if you are a defendant and you're issuing an order to have that case dismissed, that's okay, provided that in the body of it you assert your status as sovereign outside the jurisdiction, and that this is an order from your court to their court. If you do that, then it's okay to order it as a defendant. Okay? Make sense? Or did I go too fast? Okay, one more time. If you are a defendant and you issue an order to have the case dismissed against you, you must assert in the body of your order who you are, that you're sovereign relative to the state, that they have no jurisdiction over you, that this is an order from your court to their court. Okay? That's what's going to protect you. And one more thing. You want to accompany with it an order to show cause. Tell me why I'm wrong. And if they fail to answer that order to show cause, it means you're right. And you don't just tell them to file an order to show cause. You give them a deadline. When are they going to file it? You tell them when you want that order, and if that response. If they don't respond, it's locked in. And you give them time, you know. They won't answer it, apparently. I've never had one answered. I need to show cause. I don't know why.
Can it be in the body of the text?
That's what I just said.
Okay.
Yeah, it has to be in the body. There's nowhere else you can put it.
If we have anything to say a microphone, please.
Does it have to be in the body of the text, he says. Yes, of course it has to be in the body of the text. That's what I said. If you back up the tape or the DVD, you'll see that's what I said. Okay. So, we say, or if a person disobeys any lawful judgment, order, or process of the court, engages in any other unlawful interference with the process or proceedings of a court, or if an inferior magistrate interferes with the lawful judgment, order, or process of a superior court, or proceeding in an action or special proceeding contrary to law, after such action or special proceeding is removed from the jurisdiction of such inferior magistrate. See, it was removed from his jurisdiction, wasn't it, when we had a prior order? So that magistrate was kind of in the wrong position. As the magistrate pointed out, CCP section 1209 in no manner allows for a court to hold itself in contempt. That is true. But that is not the issue before this court. The issue is whether or not the accused persons are to be held in contempt. The magistrate holds only ministerial authority. He holds no tribunal authority and cannot in any way substitute himself as the total equivalent of the court to thus exempt himself from jurisdiction. CCP 1209 provides that contempt may be applied to misbehavior in office or other willful neglect or violation of duty by an attorney, counsel, clerk, sheriff, coroner, or other person appointed or elected to perform a judicial or ministerial service. The magistrate is an other, quote, other person appointed or elected to perform ministerial service, as described in CCP section 1209. Depriving anyone of the right to have his day in court is very serious. The magistrate has a duty to the plaintiff to minister the opportunity to argue the petition put forth by the deputy clerk. Here's a quote, very important quote. You ought to keep this one in mind for future writing. He who decides a case with the other side unheard, though he decide justly, is himself unjust. Okay? And who said that? That was by Seneca, an ancient authority. I think, wasn't he one of the heads of Greece, of Athens? Philosopher, highly respected. So, anybody? So, he is himself unjust. To summarily remove a First Amendment action that has been previously sanctioned by the court constitutes a direct challenge to the court's authority, especially when the magistrate's judicial jurisdiction is estopped and he tacitly declines a fair opportunity to show cause why he should not be subject to estoppel. California Code of Civil Procedure provides that when the contempt is not committed in the immediate view and presence of the court or of the judge at chambers, an affidavit shall be presented to the court or judge of the facts constituting the contempt. In this instance, an affidavit of the facts constituting the contempt was presented to this court and not to a judge. Notice that, by the way, this is a quote out of the code, okay, that the affidavit has to be presented. An affidavit shall be presented. Notice what it says, to the court or judge. Okay? See, they recognize what a court is and what a judge is. They're two different animals. Okay? Again, what's a court? The person and suit of the sovereign. Who's the sovereign? That's right, you are. Okay, so in this instance, an affidavit was presented. Okay. There was no opposing affidavit. California Code of Civil Procedure 1211.5 provides, if no objection is made to the sufficiency of such affidavit or statement during the hearing on the charges contained therein, jurisdiction of the subject matter shall not depend on the averments of each affidavit or statement, but may be established by the facts found by the trial court to have been proved at such hearing. Okay? Normally, had he objected, then you would have had some issues. But since he didn't object, the court can move on. It now has jurisdiction. Okay? Failure to object means you agree. Same old principle. Okay? Impeachment and penalty. The court, having reviewed the facts in the record, finds that I hold the filings as a judge not guilty of contempt of this court, and Roy Legoumet as a judge guilty of contempt of this court. And Roy Legoumet shall pay a fine of $1 within 60 days of entry of this ruling. If the fine is not timely paid, or if this court in the future should otherwise see the need, this court shall forward appropriate notice and a copy of all transcripts and papers in this matter to the California Council on Judicial Performance. And attorney's fees and costs awarded to William Jones, none asked and none awarded. Execution of this order shall be stayed pending the filing within 6 judicial days of a petition for extraordinary relief testing the lawfulness of this court's order, or a notice of intent to file within 30 days a motion for reconsideration. Now, that little phrase there was put in because when a court in California finds an attorney in contempt, he gets that privilege. So what we did, even though there was no specific code to that effect, we did the same thing for the judge. Again, what are we doing? We're showing we're fair, we're considerate. Every opportunity is being extended. He never did it. Okay? Witness. No. No. What happened was he was pulled off of our case by the presiding judge. What is the purpose of contempt? 2 purposes. 1, preserve the dignity of the court. 2, preserve the authority of the court. When he was removed, that was gone. There was no need to enforce anything. We had a new judge come in. We looked up the dossier of the new judge, or what they call a profile. The law library has profiles of all judges. So we looked up the profile, and the profiles on this new judge said that he was a member of a private group of judges that studied the common law. He was a specialist. Tell you what else it said about him. This was a superior court. Now, the superior court has an appellate division, and the appellate division hears appeals from the municipal court. If you lose in a municipal court, you can appeal either to a regular appellate court or you can appeal to the superior court appellate division. Now, the appellate division of the superior court is a very, very high quality court. The guys that are in that staff that, are very sharp, very experienced, very knowledgeable. And these guys in the appellate division of Superior Court, when they write an opinion, it has precedent value just like an appellate decision does. Okay? So we're not talking about schlocks here. We're talking about guys who know what they're doing. This man that they assigned to our court was their big gun. He used to be the presiding judge of the appellate division. Okay? So he was a specialist in common law. He was a sharp on other laws. So we decided, all right, we'd let him in because it'd be nice to deal with somebody who's knowledgeable. And he was knowledgeable. So anyway, that was the contempt ruling. And that contempt ruling will be extremely valuable to you when you write your own decisions, because the entire chain of logic is there that leads from the Constitution right down to the court level as to why you're boss and they are not. Okay, that's what makes it useful. I go back, I forget stuff, and I go back and I'm pulling stuff out of there all the time for other decisions, other orders that I do. So I highly, highly suggest that you study that one, because it pounded the judge into the ground. He lost his job over it. They pulled him off of that in 900 other cases. No. Sorry. He didn't actually lose his job. He got assigned to Timbuktu, some little tiny, he was not in that main court anymore. They put him off in some jurisdiction, I don't know where, but it was same county, but a little tiny town. Okay? Yes?
How is the new judge doing? The new one?
Oh, he was educated. Like I said, he was easier to deal with. Now, he still tried, he didn't really read the case thoroughly, but I think we did issue some orders against him, correcting him. I didn't publish them here because it doesn't add anything. It's the same old stuff. Just waste your time. What you've got is complete. This is a good model to learn from. And so if you learn by experience, like one guy said to me, he was really upset at me. He says, I want to see another example. I said, well, you don't understand the first one. How are you going to understand the second one? Okay? Because he wouldn't do the homework. He wouldn't read it. And I could tell by the questions he asked, he never even read it. So I just blew him off. I just said, well, and then that really upset him that I didn't care and so on. That's the way it goes. But anyhow, no, seriously, everything, I found it over and over again, I found it useful for other things. And it's interesting, we've never had a single order to show cause responded to. Isn't that amazing? You'd think they'd say something, even if they were wrong. Okay, well, you want a break or something? Yeah. We haven't had dinner, have we? 7.
Bill, has this case been completed?
No. I have yet to write the final judgment. That's next.
Thank you.
The case has not been completed. Okay, well, we've had our break here. Any questions? Yes. Over here. Any questions before the microphone?
All right, could you clarify when you use the master and when you're, now I forgot the rest of the part. When you're there as the master versus when you're there as the sovereign?
Well, when you're a sovereign of your own court, you're always a sovereign. You're never the master. Okay? You're never the judge. You are in your own capacity as the sovereign of the court. And if if your court makes a decision, you're the highest authority. It's not appealable. Okay?
So when would you be the master?
You're never the master of your own court.
I thought in the earlier part this morning there was a time when we were
That was somebody else's court that I was master in.
Okay, thank you.
See, a master, look, you're the sovereign of the court. You're the do-all and be-all of the court, okay? And between you in your sovereign capacity and your suit, between those two, you now have created the court, the artificial entity called a court. And now, just imagine, a lot of these questions about courts can be answered by setting your mind back to the 15th century, and just imagine that you're the king of the realm. And if you were the king with one subject, you have a relationship, right? You own the subject. Well, as you grow in activity, you start hiring people to manage your affairs. And finally you get so big, you peel off the court system, make it a separate court system, you hire the judge, and you tell the judge, you're my mirror. You have to do things the way I want it to be done. I'm the lawgiver, and you are the administrator. And so you hire people, in effect, to carry on various tasks. And so that's what it is here. Now, here in the United States, you are sovereigns without subjects. But that's not strictly true, because people become your subjects when you hire them. Okay? It may be just a conditional type of thing. And who are your subjects? Well, you have the judge of the court, you have the clerk of the court, you have the, who is it, the court recorder, you got the marshal. All of these people are in your court. They're in your jurisdiction when you're running your case for that moment. And your chief warehouseman for your paperwork is called the clerk of the court. And they'll warehouse your papers forever, okay, at a very reasonable price when you think about it. What would it cost you to set up a deal like that and make sure whatever papers you had were always available to everybody? So in the case where I was a special master, that was because the sovereign himself couldn't do it because he was in jail. Okay? He was too busy, wasn't he? So he appointed me as a special master in his court in the same sense that a judge would be appointed. Only thing is, I didn't get paid. Okay? But that's what it was. I was just taking over a function that the sovereign was too busy to do himself. He can be his own clerk if necessary. But there are certain advantages. I mean, heck, a couple $100, whatever they charge for it, and you get the entire staff available to you. You get the judge, the clerk, the marshals, enforcement, you know. That's literally true. Okay, any other questions? Next question. Okay, well, I guess. Say again?
How do you shut down the court in 5 minutes?
How do you shut down the court?
No, the hearing. How is it that you get the hearing to only last 5 minutes?
Well, it's because whatever the hearing is, no matter what it is, you've done all your talking on paper. There's nothing to talk about. Okay? So the only thing is that they might do things. For example, a very typical thing that happens is that the opposing attorney will start offering information to the judge. Information that was never in the paperwork. Well, that's not legit. The whole purpose of a court hearing is to give the court an opportunity to clarify something you wrote. If in one case somebody told me that there's a court that he's going to, the judge won't even let him talk, won't let him have a hearing. And I'm telling him, that's right. He doesn't have to, because he has no questions to ask you. Okay? You said everything you're going to say in your paper, and that's it. All right, now the judge, if the judge or the court is confused about something, needs more information, call you in, ask you, query you, but he cannot give any new information. He can argue the case based on the existing information that was submitted in the paperwork. See, the normal timing, and I discussed this in the last seminar dealing with motions, that in your normal timing is you make a motion and there's a hearing is set 30 days after you make the motion. And then the other person has 20 days to answer. So 20 days later, he comes through with your answer. you now have 5 days to reply to his answer. That leaves 5 days for the judge to read it, to read all the information. They have to have it filed. So that's kind of the timing. He files the motion, 20 days to answer, 5 days to reply, and then 5 days for the judge to read it. And then you have the hearing. So that's your sequence. Now, you make all your arguments, whatever you're going to say. Well, if whoever made the motion first, he says what he's going to say. In the reply, or in the answer to the motion, you say whatever you're going to say. But you deal with the motion. You don't deal with other issues. So there's kind of a restriction on it. If you put other stuff in, if you wander all over the conversational map, well, a lot of your stuff will be thrown out because it's not related to the subject at hand, the motion. And then when the other party replies to the answer, the reply is restricted to the issues that are there. Can't bring in any more facts. Why? Because there's no follow-up paper that will allow him to argue against whatever new information you bring in. So you can't bring in new information. Then when you show up at the hearing, the only purpose of the hearing is that, you've read all the discussion, read those 3 papers, motion, answer, reply. Judge has read all 3, confused about something, this is an opportunity to ask questions. If he doesn't if he doesn't ask any questions, well, that's it. Decision's next. Go ahead.
I was in an arraignment court about a month ago, and the complaint and the declaration was not signed by anyone, and I pointed this out.
Mm-hmm.
And so then the prosecutor the judge gave the prosecutor the piece of paper.
Right.
I mean the commissioner.
And he signed it.
And then he marched it over to the deputy DA.
Right.
And she signed it.
Okay. Yeah.
Yeah.
Okay.
But how can they can't be an injured party? How can they do this? There's no way. This is 3 years old.
They're representing the state. Look, now understand this, that the real world is common law.
Right.
The fictional world is statutes.
Right.
You can do anything in fiction.
Right.
Okay?
Right.
And so they chose to do that extraordinary procedure, and the judge in this fictional statutory world has the discretion to apply the codes in order to effect justice, whatever that means in his mind.
Right.
Okay? You grant him that kind of discretion, you get bad results.
Right, but I did not grant him, and I recused him, but he still went on ahead and did it anyway.
They went and got it signed. Let me tell you something. In your strategies, what you should do when you find defects, learn from this. This is a good learning point. When you find a defect in the opposition, you need to use some strategy. I know, on the one hand, I've said failure to object means you agree.
Right.
But, on the other hand, don't educate the other side.
Right.
Don't tell them what's wrong so that they can fix it. Okay? So, in one sense, you've got to use a little strategy here. But if you don't make them correct it, if you don't tell them about it, you have to have an exit plan. In other words, if you don't tell them then, what are you going to do with that information? Because at some point, that's good information that would torpedo his case. But where's your strategy as to exactly when you're going to reveal it to them? Because you don't want to reveal it at a point where they have time to correct. It might be nice to raise that point at the actual trial. Oh, it might during allocution you could raise it. Yes. Go ahead, lady.
So when you do a motion, you only go into the hearing to discuss the issues in the motion, and if someone...
No, not to discuss it, to answer the court's questions. You've already discussed it in your paperwork.
Okay, to answer the court's questions. If someone tries to bring up new
I
facts, you just say, I object?
That's right.
That's it?
Right.
You don't even give a reason why? You just say, I object?
Well, you give a reason if he asks you why. Why do you object?
Mm-hmm.
You say, well, that's not my wish. And you might even say something to the effect that it's not my wish that new information be allowed in. He had his chance. What are you doing? Trial by surprise, is that the technique?
Thank you.
Good. Thank you for bringing that in, because, yeah, usually you object to new information, it's not allowed.
They do it
so
all the
your
time.
phraseology puts it perfectly in the framework, what you wish as well as what they want to hear.
Right. But then you see, if you do a counterclaim and you show up at the hearing, and you can set the date of the counterclaim on the same date as that hearing, okay? Basically, the idea is that when you appear, you're not appearing as a defendant, you're challenging jurisdiction, so their case is suspended, so the only purpose of the hearing has to be to hear the counterclaim, something relating to counterclaim, and that puts you in charge then, and then you can make your wishes known.
Excellent. In those situations in which you are a defendant, though, I've usually find that judges don't bother to read the paperwork, and if you don't bring it up orally to point their attention to certain things, they'll just slam dunk you.
Well, that's true, but in this case, if you do a counterclaim and they fail to read it, who's in charge? And who's going to issue the order vacating his decision when he wasn't allowed to make a decision in your court? Okay.
March 3rd, I was raided by the IRS. They took our records, took our files, computers, everything.
That's an excellent point. Now, those records are now contaminated. They're going to try and give those records back to you later.
They did. They gave back our computers, but not the records.
That's fine, because at some point, the judge or whoever is going to demand that, like, you file returns that you're refusing to refile or whatever. I don't know what the case was, but the point is that often they will say, we want you to produce some kind of filing report, whatever that. And when they do that, you say, I'd love to, if I could, but I lost control of the records. They were put in the hands of somebody who's an adversary, and I have absolutely no assurance that they're correct anymore.
Okay. Okay. But Bill, my question is,
well, tell them that. Why
Bill,
don't you get up and say that?
You're under criminal investigation if they will never ask you to produce records again.
Right.
Well, that's not true, because I know people where it's done. They have asked for records.
So my question is, how can I sue the IRS agent that did this?
Well, just sue them.
A state court?
You could do it in a state court. In fact, that's an interesting technique. Remember that the states and the federal government, each is a foreign entity relative to the other.
Right.
There are certain exceptions to that, but basically they're foreign entities. So one of the duties of the governor, by the way, is to protect the citizens of the state from attack by a foreign entity, and that includes the federal government. Now, they won't do that, of course, because they're in bed with each other.
Right.
But basically, that's a duty, and you might be able to lean on that some way. But actually, I would say that you do your counterclaims, and you know they now.
No, there's been no action against me. What I want to do is an action.
Yes, there has been an action. They stole your records.
Oh, okay.
It's a theft. If there's no action, if there's no legal, no court orders, that's a theft.
Right.
Do a counterclaim based on common law theft.
Okay.
And that would be, and theft, by the way, that would be a trespass. Okay. A trespass under common law involves violence, false arrest, deprivation of rights, taking your materials. That's all violence.
They had a search warrant, but no probable cause affidavit attached to it.
Yeah, that is theft. If it's not proper, it's theft.
Okay.
Also,
okay? And I'd assume on that basis, do a counterclaim, or do a claim since there's no action filed yet. Do an actual claim. Now, here's another interesting thing.
Oh, one.
If you do your claim before they've done any official action like that, you know, an actual complaint against you. Right. Now, as soon as they do some sort of a claim, whatever it may be, you now can raise the issue of vindictive prosecution. Now, the thing about a vindictive prosecution, prosecution claim, is that when you raise the issue of vindictive prosecution, that is the one issue that you do not have to prove. The burden of proof is on them to prove that the government is not vindictively prosecuting. That's an automatic.
I have a question. Did you get their pocket commissions?
No.
Okay, maybe in discovery you can
So
request
is
their pocket
is that
commissions?
all on the record here? Are we recording that?
Yeah, he's.
If I go common law, there is no discovery.
Who has the microphone?
I do.
Could you hand it to him when he answers?
No, I did not do. I did not get their pocket commissions, and if I file under common law, there is no discovery.
That's correct. You provide all the evidence that you have up front.
Right.
And there's no evidence, no discovery, because you have no more evidence to offer.
Right.
But yeah, I'd claim theft right up front. They took it without the proper stuff, and then when they do come back with something, I'd claim vindictive prosecution. And the burden of proof is they actually have to prove it is not. I'm not sure how they prove a negative, but they have to prove it's not vindictive. Yes.
A raid is also an unreasonable search and seizure.
Why is that?
Because it violates the Constitution.
Well, wait a minute. Just because you put the label raid doesn't necessarily mean it's unlawful. I mean, if it's proper warrant and all that sort of stuff.
It was not a proper warrant.
Yeah, I know that, but he's making a blanket statement that a raid is.
They cannot raid you. They have to have a warrant. They just can't. A raid means they
What
just.
if they raid you with a warrant?
Well, then it's not a raid.
That's what they call it. Okay, you know, again, who's running the definition of the words here? Okay. Well, any other questions? We're in the last hour. We're going to cut off at 9 o'clock on the recording. We could stay and talk a little more, but okay, a couple questions here. Yeah. You want to? Oh. All right. How can we turn a 23-member legal grand jury into a 25-member lawful grand jury? Well, that's not the subject of this seminar, and besides, I don't know. However, my sense of it is that all of the grand juries are statutory grand juries, not common law grand juries. If you want to know about a common law grand jury, read Article 61 of the Magna Carta, and I'm not sure. I think it's Article 52, maybe 51 or 52 of Magna Carta also. But 61 lays out the procedure on how a grand jury is formed and what the powers of a grand jury are and what procedure should be followed when there's a complaint against the government. So look that up. But basically, the grand juries presently are all statutory grand juries, which means to me that they're not genuine grand juries. Plus, they don't have 25, which is the number specified in the Magna Carta. So I'd say that if you want a real grand jury, follow the Magna Carta procedures, form your grand jury, but right there you have no credible power. Legally you're correct, but you're still not credible. So I would suggest that the next step is, before the grand jury did anything, that you go to the court administrator and ask for a room to meet in the government building. Because if you go through the procedure and get an actual government spot to meet in, there will be your credibility. Okay? And you may have to do battle, you may have to sue them to get the space and so forth. But once that issue is settled and you achieve credibility, then you can start acting as a grand jury. And then I would suggest that if you act as a grand jury under those conditions, that you pick small, obvious things. Just small stuff, obvious stuff, so that you build credibility. Otherwise, you can bet they're going to take the first opportunity they can to call you a kook, a whole collection of kooks, and undermine your credibility. Okay? Got a question?
Next. Yeah. I had some funds in a private bank account, which was commodity account.
Sure.
And if they took those funds, the government took those funds because
Sure.
they were in an account. So is there a way, they didn't sue me, they didn't raid me, but
No,
they
you
took
sue 'em.
funds.
You're the injured party.
Okay, so I can still step in there.
Absolutely. They got your funds. They won't give them back to you.
Right, okay.
In fact, as I recall, in that case, they actually misapplied the funds. They admitted they got it, they took it, and they're using it for something else.
Well, are we talking about the government, or are we talking about the person that I had them invested with?
Talking about the government that raided the person's accounts that was keeping them for you.
Okay, yeah, because I want to do a letter on that and go in as a counterclaim. Is that?
No, you don't. You just do an original claim. You go after them.
Oh, I just do an original claim?
Sure, you're not. They're not attacking you. They're only stealing your property.
Right, so I would go after the government. That is, okay,
yeah.
Thanks.
You handed your money over to somebody in trust. That person got raided by the government, and they took your property.
Right, because they're acknowledging it's my property.
Right,
right.
And that's all the better. So now, and they're refusing to give it back. So you now have a cause of action.
Right, okay, thanks.
Bill, regarding her question, would you then file a RICO against the stockbroker that had her money as well as the agents?
No, I mean,
the IRS?
Be real about this. You don't have to sue everybody in sight. Just sue the bad guys. The guy that got raided, it's not his fault he got raided.
But he probably gave the money away without due.
No, we know this guy. He's a pretty straight guy.
Oh, I see. Okay, all right.
We know, but you know, you don't just assume that just because you got harmed, you don't necessarily have to follow the chain that your money followed. You can go straight to the point of where the trouble started. Okay, let them explain it. Let them explain why you shouldn't have your money back.
Okay, with regard to since we're talking about the IRS. As many of us here in this room know, Joe Bannister about a month, 6 weeks ago, was arrested for consulting as a CPA, telling people about the IRS not being legal, et cetera, with employees. Now, if you were Joe Bannister, how would you respond to the IRS?
Well, I don't know enough about his case, but the logical general answer is that you do a counterclaim. Mm-hmm. Because after all, look, all the cases, there's details all the time, okay? You can get inundated with details in different cases. But the basic principles remain the same. Somebody done somebody wrong. So you sue. Okay? That's all. Just sue them. Because they did and because you're at law, you're suing at law, because you have that lawsuit going in common law, and you're the sovereign, you decree what the law is. How did they harm you? And then the jury, if there is one, will decide the law and the facts. But if there's no jury, you decide whether or not they're guilty. It's a good system.
Bill, I have a friend who's in federal prison in Texarkana.
Mm-hmm.
He was put there because the Justice Department came after him for securities violations, which he didn't do. Mm-hmm. Is there any way to use this process to get him out of jail? If I'm the special master, could I represent him? Or
well, don't be anxious to be a special master, especially if he doesn't need it. All he has to do is, you can put the. I suppose what you could do is you could put the paperwork together for him. Have him sign it. You just send it to him, mail it to him. He mails it back with his signature, and file these papers for him. And if he runs interference, what you ought to do is get a seal, because when you have the man's seal in possession and he acknowledges that's his seal, that becomes as good as a signature. You can sign papers for him if you seal it each time.
I see.
And
his wife has power of attorney for him.
Yeah, but this is different. Oh. Okay, you just get the seal. That's good. That's power of attorney enough.
Okay.
But you put the seal on. And what I do is when I'm doing a seal for someone else, I seal the papers just by crimping the paper. But if it's an order, I put the gold on it and seal it.
I see.
Yes. Oh no, come on up.
He can file a habeas corpus.
You can come up. They can't hear you when you're back there.
He can put in a habeas corpus for his friend. You have to prove it on the record.
Well, that's true.
And so forth.
Anybody can file a habeas corpus for anybody else. Any sovereign can come to the aid of another sovereign. Okay? When you're talking habeas corpus. So you move for habeas corpus, these people answer or don't answer, whatever, you follow the procedure. I like the procedure that is specified in Title 28. I believe it's 1441 and 1442. Is that it? Something like that. Maybe. Yeah, look in the Federal Rules of Civil Procedure. Look up habeas corpus. You'll find the section. But yeah, they have a very nice, clean procedure laid out. So you just follow that procedure. Okay, very simple. It's about 4 or 5 paragraphs. And but anybody can file habeas corpus for anyone else. Okay. Well. Oh, okay. Well, I can read off here. You have a question. We got another one coming up here.
After you file a habeas corpus, how do you proceed to its end?
It tells you in the procedure in that title. I don't have it memorized, but I know it's there.
And then you issue the order for the judge to sign?
Yeah, yeah. You could put together an order for a judge to sign. If he refuses to sign it, what you can do is, remember this, that when you put together your court, you hire various personnel to sit in your court. You know, the magistrate is there. You're hiring him not for his judicial capability. You're hiring him for his administrative capability. He's supposed to carry out the orders of your court. So he has basically an implied contract with you. That's his job. And he does it for free. Your court is not charged for the magistrate that's provided by the government. So when you finally come to a conclusion, you present it to the magistrate for signature. If he refuses to sign it, and you have given him a proper order to sign it, then what you do is you go to his boss, all right, which would be the appellate court, since he's on the district court level probably. You go to the appellate court, and the issue is not the habeas corpus at all. You already got to the judgment. The issue now becomes, why isn't he fulfilling his contract? He has a duty to the court to obey the orders of the court, and you want a mandamus ordering him to do it. That's what I would do. Or take it up to the Supreme Court. And also, since he's a federal officer, you could also try complaining to the congressman, but not just a complaint. Ask the congressman to start impeachment proceedings against the judge because of how he's behaving, because the Congress can dump a judge anytime. They just have to impeach him. It's not easy. They probably won't respond, but you know, if you can make him look bad enough, they just might do that. I'll tell you this, no judge wants to have a request like that go in, because after all, his promotion abilities, you know, he wants to rise up the ladder, and if the Congress is considering impeachment, even if they turn it down, in future it's going to look bad on his record. Got a suggestion here. It's something I'm not familiar with, but I've heard before, 21 silver dollars for court costs. And I don't understand the philosophy behind that or anything, but now the Constitution, from what I know, the only time it talks about $20, and this appears to be $1 more, is in the 7th Amendment, which says that that a jury trial can be had in civil trials. But you know, again, I don't know that. You know, that's what you can sue for, so you make sure you fall in that category. But of course, that was put together back in the days when $1 a day was a typical wage, wasn't it? So, of course, they haven't changed the Constitution. So, but anyway, you're getting into an area I don't understand. Somebody else will have to conduct that seminar. So I only know certain basic things. So, okay. Huh?
Remember my brother-in-law that came to the meeting? He went to make a police report with regards to the off-duty police officer that had admitted in court and part of the record and part of the transcript that he did take, that the off-duty police officer reached into the trunk of my brother-in-law's car and took a bag out of the car, not knowing what was in the bag, so he did admit to taking it from his vehicle. So my brother-in-law went to make the report to the police in Norwalk, and they refused. They sent, like 3 times they came out to the house to take the report, but never ever took the report and refused to take the report.
Right.
And then he reported it. Who's the agency that?
Well, look, all a report does is put it on the record, their local police record, which then the district attorney can look at and decide whether or not to prosecute. That's all you're doing with a police report. It's not like you're really doing anything against him.
Okay, but they're refusing to take the report.
Well, that's fine. You know, they're obviously protecting their own. But you don't have to put up with that. Okay? There's a real easy way to get a report going. It's called a lawsuit. All right? Put everything you would have put in the report, put it in your lawsuit and sue him. Now it's really public. He's been sued for misbehavior in office. Don't depend on the prosecutor to do it or the cops to do it.
Okay.
You know, I know I've been down that road where I reported somebody to internal investigations of the LAPD, and you know, they whitewash everything. I mean, I know that from personal experience. Other people have reported it. That's what happens. So you can make it public if it's really serious enough. Sue them. That's what courts are for. Yes, ma'am.
Well, when public officials fail to perform their duty, I think you ought to consider a writ of quo warranto to remove them from office.
Well, that's true too, and it would be interesting if you had a grand jury of 25 and issued an order to remove somebody from office, because it is written in the California Code somewhere that a grand jury can remove someone from office.
It's very interesting that Bill Locke has put on his website, the state attorney general, all these. First of all, they're doing a whole reapportionment, and they're also, he also put on the site warning these public servants that they better start acting right. If you go check the site out, it's very interesting.
Oh, okay. All right. So what is the chain that you would follow to get there? Do you have an idea roughly what it is?
What, to get where?
To the website you're talking about.
To the website it's attorney, it's AG.
Yeah, you get to the Attorney General's website. What do you click on?
Oh, it's right there. It says, it talks about, Attorney General warns public servants to you know.
Is that just on the front page then?
Yeah, it's right on there. It's right on this, right on the site.
Well, you know, look, I have maintained that not everybody in government is dishonest.
That's right.
There's a lot of good people there that do want the system to work, but it's like, you know, many public officials have gone into government and have felt very frustrated because they couldn't change things for the better. Okay? So it's like a ship. A big ship is headed somewhere, and if you want to change the course of the ship, a big ship, you can only change slowly. You cannot do a turnaround like a speedboat. And so the ship of state is very similar to that. So it's all of us pecking away at it. Remember this. You know, I've been asked this question, or told, either way you want to look at it, you know, what's the point? We're not winning cases. A lot of us don't. We're not getting the results as advertised, okay? The courts are not functioning as advertised. Why do we do this? Well, for me, it's a certain degree of idealism. But here's my point. It really doesn't matter in the bigger picture of things whether or not you win your case. On a personal level, it's very important that you win your case if you can. But in the bigger picture, it's not important. What is important is that we get a team out there all over the United States pressuring public officials to do their jobs right. And it adds up. If everybody did his part, which I realize is an idealistic statement, but if everybody did his part, we would have a very quick turnaround, because public officials do not like having to hassle these attacks. okay? When they do wrong, they like to do wrong and then forget it. But if you don't let them forget it, and then they have second thoughts about hurting the next guy. And it does have an effect. I mean, I remember, I have a perfect memory of 50 years ago, okay? At that time, I was a middle teenager. But I had some awareness back then, and I remember somebody mentioning about getting rid of the IRS. And that was such an impossibility. You're not going to get rid of the IRS. You're not going to change the income tax system. That was here forever. Now, what are they even some very high-level people are talking about a national sales tax and getting rid of the income tax, right? That's right. Okay? That was an impossibility 50 years ago. Well, what's happened is the IRS has made such a bad reputation for itself. People have gone into the underground economy. The underground economy now, I think, is estimated to be bigger than the known economy. The people are refusing to file. Compliance is way down, and it's reflected in the fact that the IRS, despite the things you hear, is not getting the budget it needs. Okay? IRS used to, I remember 30, 40 years ago, that IRS used to hire the top 10% of the graduating accountants out of college, and today they're hiring the bottom 10% of those who will consider working for the IRS. A lot won't work for the IRS, okay? So the effect is there. It looks like a lot of times we think, boy, we're losing. But if you take a 25 or 50-year view, which is what the government does 100-year plans. You know, if you take it, it's true as individuals, we may not live that long, but the fact of the matter is we do our part, we infect other people with the ideas of freedom, the ideas of protecting your rights. See, I don't encourage people to attack the government. I encourage people to defend their rights, okay? And if necessary, sue the government when it tramples on your rights. That's fair and proper. To just blindly attack, that's not good. And so I'm against rebellion, I'm against revolution, but I'm sure for a strong protection of your rights and holding them to task, do counterclaims, okay? These people that exceed authority. Now, some people have mentioned RICO. And RICO's nice, too, you know, if you can show a pattern of criminal activity, violation of rights. Yeah.
Revolution is a term that comes from science. If you're going to talk about anything to go against what they're doing, it would be revolt. The earth revolves on its axis, and that's a peaceful action, and that comes from science. So if we talk about anything, it would be revolt.
Mm-hmm. Well, that if you're into word etymology, then I would say great. But I don't think that the bureaucrats think in those terms. I think the bureaucrats, you know, and as I use the word revolution, that's what they understand. And basically they associate the word violence with the word revolution, okay? And so the bottom line is that I recommend to everybody that they protect their rights and do it through the courts peacefully. What do I say? What's the motto of the nitty-gritty law school? Encouraging the government to obey the law. That's all. That's all I want. If you obey the law, everything would be just fine. Okay? None of us would be in this room, actually, if they obeyed the law. But there are those people, rogue elements within government, that don't obey the law. And that's exactly what kicks us into action. You know, there's an interesting thing about the Japanese when they took over, I think it was some island in the Philippines, okay? And it was a fairly large population in that island. And there were local people who were opposed to the Japanese takeover, and so they tended to resist the Japanese in various ways. The Japanese had a simple solution. When you find them, kill them, okay? But the problem was every time they killed one of those guys, 2 or 3 of his friends who were up until that time kind of neutral and didn't want to get involved made him mad. And if for every one they killed, they got 2 or 3 more, and it ended up so many people were against them, the Japanese could go nowhere with any confidence they were safe, and they eventually had to abandon the project.
Sounds like a rock.
Well, yeah, kind of, yeah.
Okay, kind of the question is also,
And IRL, same thing, yeah.
part of the question is also, what is revolution in this case?
Well,
and actually, who is doing it? When you think about it, it's really the bureaucrats that are revolting.
Yeah, well, I guess one way to look at it is that the members of government apparently have declared their independence from the people.
Yeah.
That's how it appears to me. But see, I don't think revolution is the proper topic here. You know, I believe that what we have is we have a common, all of us have a common interest in protecting our rights, and we have a common interest in making sure that those people in government who disobey the law need to be called to task for it. They are the ones who should be brought through the legal process and be taken care of through the courts. That's our stock in trade here, is taking care of the offenses through the courts. We do that, and if enough of us do it, and as the word spreads, and you inform other people, and as one of you gets attacked, and you tell your friends, they get mad, and they pick up on the spirit, there's a percentage that will work. Remember this, that in the American Revolution, it was equally divided between those who were pro-king, those who were anti-king, and those who didn't care one way or the other. Okay? And out of the people that were anti-king, there were 10% of the anti-kingers that were actually involved in some way overturning the king. You understand, 10% of 1/3 means 3% of the population. It only took 3% of the population to convince them to let go. Okay? So that's what we need to do. With 3% of our population, if we could get 3% of the people out there in the courts attacking, doing countersuits, and when you're attacked, now this is a strategy that I believe in. When I'm attacked, I believe in settling the attack. They want the tax from me, okay, I'll pay it. You give me a ticket, okay, I'll pay it. But I pay it with conditions, okay? Without prejudice. That means I'm reserving all my rights. Now, are you happy? Oh yeah, they're happy, okay? You paid your debt to society. You ever heard that before? Yeah. Okay? Okay, great. I'm glad to know that. Here's the problem. I'm not happy, okay? Now, I can put my full energy into attacking them in the courts, bringing suit for their wrongdoing. And not only that, they actually took your money, so they perfected their offense. They perfected the crime. Okay? Yeah. Now it's no longer excuses. And I tell you, I know some of these fines they levy seem a little high or whatever they do, but you get that out of the way, do you have any idea what you're going to cost them? Let me tell you something. A well-conducted suit at law is going to cost them a good $25,000 to $100,000 to defend. That's usually a lot more than what they're trying to get from you, okay, in terms of traffic tickets or taxes or whatever, typically, okay? Now, some are more. Look, these guys are in business. They're conducting a government business. And if you run their costs up, see, if they can put you in jail, somehow that's money in their pockets. It's not an expense like they claim. They get money. I don't know where it comes from, but they get money. Yeah. Well, federal, but the feds also get it from somewhere, okay? Person's in jail, that's an asset of some kind that they can borrow against. So, but if you settle the account and then you're suing them and they're spending money to defend the suit, where's the profit? See, that's what you want to do. The idea is your individual case, win or lose, not important in the big picture. Only important to you personally, and that's fine. You do battle as best you can. But just remember, when you can run their costs up, you're having the real effect. I'm sorry, I kept you waiting.
No, that's great. Rather than use a lawsuit as first resort, wouldn't it be better to notice them that they've caused you injury and present a claim in cases that aren't pressing, where they don't have you, they're not dragging you into court, maybe the code enforcement man came out or some situation like that? Could I have your thoughts on that? Does it reinforce your claim, your position, your perception of being fair and just to give notice?
What I suggest is that you do a notice and demand. Okay? So there you have it.
I have one comment, Bill, couple. On the subject of revolution, if people were taught that when the War for Independence started, it was a revolution. When we won the War for Independence. So I have kind of a simple procedure that I deal with. When people call it a revolution, they must be English and think we lost. So get in the habit of calling it a war for independence, and we won. Now the second thing I'd like to bring to your attention is we've got to stop this guy, because we're liable to get America back if he continues. If we can bring the common law to our understanding, and I'm the hardest guy in the world to make understand, you're going to be looking at Resurrection Day for your country. And we can send the revolutionary Tory bastards back to England again. And by the way, they're here. They're here. Yeah, the regulatory agencies are all the Tories. They're still here. But anyway, Bill is teaching something that every one of these CDs that goes out of here, DVDs, whatever they are, should be passed on to your children and grandchildren, because you see, the reason we're here is this should have been taught when we was in, junior high at least, high school. Civics they used to teach until we went to total communism, I guess. And we'll have to be thankful that Bill is going to be around for a while. Let me tell you what, if they stop this guy's action, I mean, they've been known to do that, it's going to be a cold day in hell before one of us can pick up the pieces where he's at. So the next thing I want to bring to your attention is Bill would like to be doing this maybe every 3 or 4 weeks, have another seminar, because we went through 2. The first one was on motion, this one is on sovereignty. And if he can ever get support enough to devote his time to this thing, 100% of his time, we would be the recipients of that blessing. So the next time he's due up, I don't care if it's fly shit on the wall, come and hear him. Okay, good night.
Thank you. Thank you. I hope I merit all that.
Absolutely.
But let me tell you another technique. I just want to sneak this in. Whenever you have legal procedures, statutory, there is sometimes a common law equivalent. And when they create the statutory law, they usually build in somewhere into the statutory law a statutory procedure that gives you the common law benefit you're looking for. Now, specifically, what I have in mind here is a thing called a lis pendens. Whenever you have an interest in a property and you're suing somebody about it, an attorney can file a lis pendens on the property. That notifies a future buyer or a future lender that this property is at stake, and if there's a lawsuit involved, and they might buy the property, but since it's on public record with a lis pendens, they buy it, and whoever loses, then they lose their rights to the property, they lose their money too, and it goes back to whoever sued for it in the first place, okay? Now that's the statutory procedure. If you follow the common law procedure, well, let's put it this way. If you go down to the county recorder and try to file a lis pendens, the county recorder will say, well, only an attorney can file it, okay? Now, so here you are with your lawsuit, but you can't file it like an attorney could. So In one sense, you could say, well, I am the attorney. I'm the attorney of record on my own case, and therefore I should be able to. That is an argument you can make. But there's something better. In either the Civil Code or the Code of Civil Procedure, I forget which it is. I think it's the Civil Code, Section 800 and something. I was looking for it here, but I didn't see it. I thought it was 870. But there is a procedure calling for a notice of preservation of interest. And I think this is the statutory execution of the common law procedure. And what you do in this section, it tells you that the form, how it should be made out. They actually give you instructions on it. And so what you do is you file this form with the county recorder against a property. Let's say you're suing a judge. You do a property search through a private investigator. You find out what properties he has. You then put a preservation of interest, and in the preservation of interest, you say that the basis for your interest in the property is this lawsuit against him. That immediately screws up his credit. It immediately screws up his ability to sell the property if he wishes to duck out of it. Because whoever buys the property, if you win, they lose. Okay? So keep that in mind. That preservation of interest is a good thing. I haven't found it yet, but... Okay. Yes.
You'll have to have a signed court order
That's
by...
on this pendants. This is the preservation of interest I'm talking about.
Okay. And the preservation of interest, you don't have to have it?
No. You
There's-
just go down and make your declaration.
Is there a cover letter, so they, a cover sheet?
No cover letters. Just fill out the form. You make it yourself. Actually, you make the form yourself on a typewriter, but right in the code, it tells you exactly what to put in where on the page. It's something designed for people. Okay? They don't like to brag about it. Okay? Let's see. I'm going to try and... See, I don't... Okay. Okay, go ahead, your question.
Well, actually, I just wanted to share that my girlfriend who lives in Hawaii, one of her best friends is a lawyer, and he's Japanese, and he has a little tiny Shih Tzu dog, you know, and he named his dog Sosumi.
Sosumi, okay, very good. Right.
Bill?
Yes.
Right quick, I got a thing here called the Notice to the County Clerk about filing anything. It says, the minute you receive any affidavit, it is recorded. Should you refuse to record my affidavits once deposited with you, you are committing a crime against justice under statutes at large, section 5403, and it is punishable by up to $2,000 fine and 3 years imprisonment.
Which statutes at large?
Statutes at large, section 5403, I don't know which one.
Which one?
It doesn't say.
Yeah, you got the section within this, but you need a particular statute.
Well, it's
at large.
titled LXX, Crimes, Chapter 4, Crimes Against Justice. So it's titled, what is it, L?
Code. That's code, see?
Oh, that's the code?
Okay, but if you have a code section, that works too, because then you can trace the statute. That you
And it says 5403, every person who willfully destroys or attempts to destroy with an intent to steal or destroy takes and carries away any record, paper, or proceeding of a court of justice filed or deposited with any clerk or officer of such court, or any paper or document or filed record, or deposited in any public office, or with any judicial or public officer shall, without reference to the value of the record, paper, document, or proceeding so taken, pay a fine of not more than $2,000 and suffer imprisonment at hard labor not more than 3 years or both. So you got some...
Sounds like a deal.
Yeah, we got some stuff against them if they refuse to file your paperwork.
Okay, got 3 minutes here? All right, so next question. Okay, no more questions? Is that the end of the session here? No? I'm still looking, but, you know. I'm trying trying to find that one that, okay, I think it's the Civil Code. And I think it's in the 800 series. See if I can find it. All right, we got 2 minutes at this time, so we're almost finished.
Yeah, well, Bill's looking for that. We only have 2 minutes. Let's give him a thank you.
All right, you're welcome. Thank you. Well, thank you. I hope you folks that traveled as far as you did got your money's worth. You know, some of you people cost what? It must have cost you $1,000 to get here. Yes, sir.
Well, I was just going to ask you to repeat everything. I forgot.
Yeah. What can I say? Do it in 3 minutes. But I don't see it in the Civil Code. Maybe it's the Code of Civil Procedure. Yes. If I can find it real fast.
We got 1 minute left.
Well, I guess I can't find it that fast.
Under pressure.
Yeah, it never works. No, not that one. But that's a good one to know about. Just remember preservation of interest. And you can go to the California Legislative Info website and you can find it there. You know, you can do a California code search and look for preservation of interest. You'll find it. Okay? Well, okay, I guess we're at the official end of the DVD. So you should each get a copy if you stick around long enough so I can make copies, and you'll be able to go away with it. I'll stick around a bit.
We have power almost.
The doors close for coming in at 9 o'clock on the outside, but there's many guests out there, so we can stay and talk a little bit and so forth. Thank you. Okay. Thanks. Okay.